for judges to interpret laws to suit the presumed necessities or spirit of the times, rather than being bound by what the words meant when the laws were enacted, seem implicitly to assume that activist judges will bend the law in the direction preferred by such advocates, in effect, promote the vision of the anointed. But judicial activism is a blank check for going in any direction on any issue, depending on the predilections of particular judges. While Chief Justice Earl Warren used expansive interpretations of the law to outlaw racial segregation in public schools in 1954, almost exactly a century earlier, Chief Justice Roger Taney had used expansive interpretations of the law to say in the Dred Scott case that a black man had no rights which the white man was bound to respect. It was the dissenters in that case who insisted on following the laws as written and the legal precedents, showing that free blacks had exercised legally recognized rights in parts of the country even before the Constitution was adopted, as well as thereafter. Intellectuals of the progressive era and later may well have correctly read the tendencies of their times for judicial activism to move the law in the direction of these intellectuals' goals and values, but that is neither inherent nor inevitable. If the principle of freewheeling judicial lawmaking becomes established and accepted across the ideological spectrum, then swings of the ideological pendulum over time can unleash a judicial war of each against all, in which the fundamental concept of law itself is undermined, along with the willingness of the people to be bound by the arbitrary dictates of judges. In the meantime, the sophistry of results-oriented judges can make a mockery of the very concept of law, including the Constitution of the United States. A classic case of judicial sophistry for the sake of desired social results was the 1942 case of Wickard v. Filburn, which established a precedent and a rationale that extended far beyond the issues in that particular case. Under the Agricultural Adjustment Act of 1938, the federal government had the power to control the production and distribution of many agricultural products. That power derived from the authority of Congress to regulate interstate commerce, as provided by the Constitution. Yet the law was applied to a farmer in Ohio who grew what the Supreme Court itself characterized as a small acreage of winter wheat for his own consumption and that of his farm animals. This farmer planted about 12 acres more than the Department of Agriculture permitted, but he challenged the federal government's authority to tell him what to grow on his own farm, when that produce did not enter interstate commerce or even intrastate commerce. The Supreme Court ruled that the federal authority extended to production not intended in any part for commerce, but wholly for consumption on the farm. The reasoning of the High Court was, one of the primary purposes of the act in question was to increase the market price of wheat, and to that end to limit the volume thereof that could affect the market. It can hardly be denied that a factor of such volume and variability as home-consumed wheat would have a substantial influence on price and market conditions. This may arise because, being in marketable condition, such wheat overhangs the market and, if induced by rising prices, tends to flow into the market and check price increases. But if we assume that it is never marketed, it supplies a need of the man who grew it, which would otherwise be reflected by purchases in the open market. Homegrown wheat, in this sense, competes with wheat in commerce. Thus, wheat which did not enter any commerce at all was ruled to be subject to federal control under the Interstate Commerce Clause of the Constitution. Under such expansive stretching of the law, virtually anything could be called interstate commerce, which in fact became a magic phrase justifying virtually any expansion of federal power over the years, contrary to the 10th Amendment's limitation on federal authority. In 1995, there was consternation in some quarters when the Supreme Court voted 5-4 in U.S. v. Lopez that carrying a gun near a school was not interstate commerce, so that Congress had no authority to ban it, though all the states had that authority, and most, in fact, did ban it. What made the vote close and the result surprising was that it rejected the long-standing practice of courts stretching the phrase interstate commerce to cover and rubber stamp virtually anything that Congress chose to regulate. Some judicial activists not only make rulings that stretch the law, but even go directly counter to it. A classic example of this was the 1979 case of United Steelworkers of America v. Weber. Section 703A of the Civil Rights Act of 1964 made it illegal for an employer to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race or various other characteristics. Section 703D more specifically forbade such discrimination in any program established to provide apprenticeship or other training. Nevertheless, a white employee, Brian F. Weber, was denied admission to a training program where places were awarded on the basis of seniority, even though black employees with less seniority were admitted because racially separate seniority lists were used and racial quotas were established. That this was counter to the plain meaning of the Act was not explicitly denied in the U.S. Supreme Court opinion written by Justice William J. Brennan, but Justice Brennan rejected a literal interpretation of the Civil Rights Act, preferring instead to seek the spirit of the Act and Congress's primary concern for the plight of the Negro in our economy. Because that presumed purpose was not to protect whites from racial discrimination, the Act was deemed not to protect Brian F. Weber, who lost the case. The emergence of this decision from the clear language of the Act, to the contrary, was likened to the great escapes of Houdini, in the dissenting opinion of Justice William H. Rehnquist. In all three of these examples, Dred Scott, Wickard v. Filburn, and Weber, the decisions reflected the results preferred, rather than the written law. They are classic, concrete examples of judicial activism. Unfortunately, the meaning of the phrase has been obfuscated in recent years, and so requires some closer scrutiny. Judicial activism is an idiomatic expression whose meaning cannot be determined by the separate meanings of its words, any more than the meaning of the exclamation, "hot dog," can be determined by referring to a separate definition of hot and dog. Nevertheless, in recent times, some have attempted to redefine judicial activism by how active a judge has been in declaring laws or government actions unconstitutional. However, the Constitution itself is a limitation on the powers of Congress, as well as on the powers of the other branches of government. Judges have been considered duty-bound to invalidate legislation that goes counter to the Constitution ever since the landmark case of Marbury v. Madison in 1803, so how often they perform that duty is not solely in their hands, but depends also on how often others do things that exceed the powers granted them by the Constitution. The real issue regarding judicial activism is over whether the basis of a judge's decisions is the law created by others, including the Constitution, or whether judges base their decisions on their own particular conception of the needs of the times, or of social justice, or of other considerations beyond the written law or the legal precedents. There is another idiomatic expression used for the practice of a judge who confines his role to following the written law, judicial restraint, or following the original intent of law. Here again, the meaning of these terms cannot be understood simply from the separate meanings of each word. Judicial restraint means making judicial rulings based on laws created by others, rather than being based on the judge's own assessment of what would be best for either the parties in the case at hand or for society at large. Justice Oliver Wendell Holmes exemplified this legal philosophy when he said that his role as a judge is to see that the game is played according to the rules, whether I like them or not. He also said, "The criterion of constitutionality is not whether we believe the law to be for the public good, but since the judge who believes in judicial restraint makes the existing law the paramount consideration in deciding cases, that often means that such a judge must be active in striking down new laws which violate the restrictions of the Constitution, which is the supreme law of the land. In short, activity is not what distinguishes the judicial activist from the practitioner of judicial restraint, since these are just idiomatic expressions for different philosophies of carrying out a judge's function. Judges who base their decisions on the kinds of social, economic, or other considerations of the sort urged by Roscoe Pound or Louis Brandeis are judicial activists in the sense that has stirred controversy, whether they declare many laws or few laws unconstitutional. Although Justice William O. Douglas was a classic judicial activist in the sense of paying only the most token attention to the Constitution in making rulings based on his own policy preferences, the most famous example being basing his ruling in Griswold v. Connecticut on emanations from the penumbras of the Constitution, he nevertheless deferred to legislators who passed liberal social legislation, using language dear to the heart of advocates of judicial restraint, saying that the court should not be a super-legislature, but leave social policy to Congress and state legislators. But when the existing law represented social policy that he disapproved, Justice Douglas did not hesitate to intervene and declare it unconstitutional, as he did in Griswold v. Connecticut, even if he had nothing more on which to base his ruling than emanations that he somehow discerned coming from the penumbras of the Constitution, which not even the greatest legal minds, on or off the court, had ever discerned before. The high tide of judicial activism was the Warren Court of the 1950s and 1960s, when Chief Justice Earl Warren and a like-minded majority on the Supreme Court decided to remake social policy in both civil and criminal areas, almost invariably to the applause of the intelligentsia in the media and in academia. However, as justices with a more judicially restrained view of their role later went on the court, beginning with the Warren Burger Court in 1969, many among the intelligentsia sought to turn the previous complaints about judicial activism against the new judges by measuring how active these judges were in declaring laws unconstitutional or in amending the precedents established by judicial activists such as those of the Warren Court era. Liberal journalist Michael Kinsley accused Antonin Scalia of judicial activism when Scalia wrote an opinion as a Circuit Court of Appeals judge, which, in Kinsley's words, overruled a major piece of legislation passed by large majorities in both houses of Congress and signed with a flourish by a popular president, as if these were the things that make a law constitutional. Linda Greenhouse of the New York Times called the decision that carrying a gun near a school was not interstate commerce an exercise of raw power by the Supreme Court, because in U.S. v. Lopez, it invalidated a law that two houses of Congress and the President of the United States approved, as if other laws overruled by the Supreme Court as unconstitutional, ever since Marbury v. Madison in 1803, were not also duly passed laws. Under the title, Dissing Congress, a Michigan Law Review article said that the court in Lopez had taken an important step in developing its new version of judicial activism, under which Congress was accorded less respect for its handiwork. Senator Herb Kohl likewise denounced the Lopez decision as a piece of judicial activism that ignores children's safety for the sake of legal nitpicking. However, the Washington Post took a more measured view in its editorial on the case. One would never guess from the senator's comment, for example, that most states already prohibit the carrying of weapons in schools. In fact, Alfonso Lopez, the San Antonio teenager, whose conviction was reversed in this case, was initially arrested on state charges that were dropped only when the federal government took over the prosecution. Clearly, the invalidation of this statute does not leave the nation's children vulnerable at their desks, and it may cause federal legislators to think twice about rushing into every problem area without even considering nitpicking questions of federalism. Senator Kohl was by no means the only lawmaker to argue in results-oriented terms, rather than in terms of constitutional limitations on federal power. Senator Arlen Specter said, "I think that crime is a national problem, and guns and drugs are the principal instrumentalities of crime." But liberal law professor Lawrence Tribe saw beyond results-oriented criteria in this case, as reported in the Chicago Sun-Times. "Congress has pushed the outer edge of the envelope rather carelessly," said Harvard Law School professor Lawrence H. Tribe, who noted that lawmakers did not present findings of a link between interstate commerce and the dangers of guns on school grounds. He said the ruling revealed that this court takes structural limits to Congress's power more seriously than people had thought, which liberals and pragmatists find dismaying. The new definition of judicial activism included not only failing to defer to Congress, but also the overturning of judicial precedents. In Linda Greenhouse's words, the Lopez case was the first time in 60 years that the court had invalidated a federal law on the ground that Congress had exceeded its constitutional authority to regulate interstate commerce. But judges take an oath to uphold the Constitution, not an oath to uphold precedents. Otherwise, Dred Scott and Plessy v. Ferguson would have been set in concrete forever. The Lopez case was by no means the only one that caused many among the intelligentsia to denounce the later Supreme Court for judicial activism on the basis of its having declared some law or policy unconstitutional. Professor Cass Sunstein of the University of Chicago lamented in 2001, "We are now in the midst of a remarkable period of right-wing judicial activism. This has produced, among other things, he said, an undemocratic judiciary, when in fact an appellate court with the power to overrule laws passed by elected officials is inherently undemocratic, so that Professor Sunstein's complaint would apply to the Constitution of the United States itself, rather than to those who carry out their function under that Constitution. Yet Sunstein complained again in 2003 that the Rehnquist Court has struck down at least 26 acts of Congress since 1995 and is thereby guilty of illegitimate activism for, among other things, having struck down a number of affirmative action programs, as well as striking down federal legislation as beyond congressional power under the Commerce Clause. According to Professor Sunstein, the Supreme Court has forbidden Congress from legislating on the basis of its own views of what the 14th Amendment means. But if Congress can determine the extent of its own powers under the 14th Amendment, or any other provision of the Constitution, then the Constitution becomes meaningless as a limit on congressional power or on government power in general. In a similar vein, an article in the New Republic titled Hyperactive, How the Right Learned to Love Judicial Activism claimed that conservative judges have turned themselves into the mirror image of the judicial activists whom they have spent their careers attacking. Using this new redefinition of judicial activism, a New York Times writer charged Chief Justice John Roberts with sometimes supporting judicial action even if it meant trampling on Congress and the states. A later New York Times editorial declared a willingness to strike down congressional laws to be the most common objective criteria of judicial activism. This redefinition sidesteps the whole crucial question whether the laws overruled were in fact consistent or inconsistent with the Constitution of the United States. But this key issue is repeatedly left out of claims that the Supreme Court is activist when it fails to uphold legislation or particular precedents. The new definition of judicial activism lends itself to a purely numerical basis for deciding who is and who is not a judicial activist. Professor Sunstein, for example, basing his charges on how many federal laws per year the Supreme Court has declared unconstitutional. That notion has spread from the intelligentsia into politics. Thus, Senator Patrick Leahy used this new definition of judicial activism when he asserted, "The two most activist judges we have right now are Justice Thomas and Justice Scalia, who have struck down and thus written laws of their own in place of congressional laws more than anybody else on the current Supreme Court. Since these are the two justices most identified with judicial restraint, it was a verbal coup to turn the tables and label them conservative activists. Blurring the line between judicial activism and judicial restraint not only defuses criticism of liberal activist judges, but enables points to be scored by invoking moral equivalence against judicially restrained judges who can also be called activist by simply redefining the term. Genuine judicial activism, like many other social phenomena, may be more readily understood by examining the incentives and constraints facing those involved. One constraint on judges' actions that has clearly weakened over the years is the disapproval of peers, whether in the judiciary or among legal scholars in the law schools. Judicial activism for litigants or causes favored by the prevailing vision of the intellectuals can expect acceptance, at a minimum, and in many cases celebration or lionizing of activist judges. In short, incentives favor judicial activism. Judges, like intellectuals, usually become famous among the general public only when they step out beyond the bounds of their professional competence to become philosopher kings, deciding social, economic, or political issues. Not even Chief Justice Earl Warren's admirers tried to portray him as a great legal scholar. Both he and Chief Justice Roger Taney, a century earlier, became famous for making sweeping pronouncements about society on a sociological rather than a legal basis for their landmark rulings. With pronouncements going beyond the range of their expertise or competence being virtually a prerequisite for popular prominence, it is hardly surprising that so many judges, like so many intellectuals, have said so many things that make no sense. Judicial restraint and original intent. Judicial restraint has sometimes been summed up in another idiomatic expression, namely following the original intent of the law. Many among the intelligentsia have seized upon the word intent to claim that it is difficult or impossible to discern exactly what those who wrote the Constitution, or legislation for that matter, actually intended, especially after the passing of many years. Thus, Professor Jack Rakove of Stanford University said, "Establishing the intention behind any action is a tricky business, and the task grows geometrically more complex when we try to ascribe intent to groups of people, especially men who were acting 2 centuries ago, who left us incomplete records of their motives and concerns, and who reached their decisions through a process that fused principled debate with hard-driven bargains. The key word in all of this, and the key fallacy in this common line of reasoning, is the word behind. practitioners of judicial restraint are seeking to understand and apply the written law as it stands, as instructions for both judges and the citizenry, not discover the motivations, beliefs, hopes, or fears that might have been behind the writing of the law. Judicial restraint means undertaking an inherently less complicated task. Even the simplest law, such as a 65 miles an hour speed limit, can be expanded into a complex question of unanswerable dimensions if looked at in terms of the attitudes, values, etc., behind the intentions of those who created that law, rather than being looked at as an explicit instruction, readily understood. Looking at laws in terms of the subjective intentions of those who wrote them is not only a more complicated approach, it is an approach that seeks, or claims to discern, the value judgments or the spirit behind the laws, which gives judges far greater latitude for interpretation, and thus far more opportunities to adjust the laws to meet the needs of the time, social justice, or whatever other synonym for the individual predilections of particular judges. But critics of judicial restraint project such difficulties onto others who are not looking behind laws, but undertaking a far more straightforward task of reading laws as explicit instructions, rather than as general statements of values. As Justice Antonin Scalia put it, despite frequent statements to the contrary, we do not really look for subjective legislative intent. What he is seeking is the original meaning of the text, adding, often, indeed I dare say usually, that is easy to discern and simple to apply. Nor is Justice Scalia unique in this. From William Blackstone in 18th century England to Oliver Wendell Holmes and Robert Bork in 20th century America, those seeking to stick to the original meaning of laws have made it very clear that they were not talking about events taking place within the inner recesses of the minds of those who write laws. For one thing, the votes which provide the political, legal, and moral authority of laws are votes on what is publicly set before those who vote. In other words, nobody voted on what was in the back of somebody else's mind. Moreover, nobody can obey or disobey what is in the back of somebody else's mind. It was the publicly known meaning of the words of the laws, to be understood in their usual and most known signification, as at the time they were used, according to Blackstone, that determines how a judge should interpret them. For Holmes as well, legal interpretation of what the lawmaker said did not mean trying to get into his mind. Holmes said, "We do not inquire what the legislature meant. We ask only what the statute means." In a letter to British jurist Sir Frederick Pollock, Holmes said, "We don't care a damn for the meaning of the writer." The judge's job, according to Holmes, is to read English intelligently, and a consideration of consequences comes into play, if at all, only when the meaning of the words used is open to reasonable doubt. Judge Robert H. Bork has likewise argued that judges should render decisions according to the historical Constitution. Despite such plain statements by advocates and practitioners of judicial restraint over a long span of years, much verbal virtuosity has been deployed by others to expand the task to unachievable dimensions by turning the question into one of discerning subjective motives, beliefs, hopes, and fears behind the creation of the law. Professor Raykove, for example, said that at the time of the Constitutional Convention in 1787, James Madison approached the convention in the grip of a great intellectual passion, that he had fear of certain policies regarding property and religion, and that he privately described constitutional amendments in a particular way. Similarly, Professor Ronald Dworkin has argued at considerable length against original intent, on grounds that the mental events in the minds of legislators or writers of the Constitution are difficult or impossible to discern, that it seems even plainer that we have no fixed concept of a group intention, nor any way of deciding which aspects of individual mental states are relevant to a group intention. Justice William J. Brennan likewise spoke of the sparse or ambiguous evidence of the original intention of the framers of the Constitution. In a similar vein, others point out that public statements often do not reflect actual intentions. Such attempts to change the question from the plain meaning of a law to an esoteric quest for discovering what was behind the creation of the law are often used by those who espouse judicial interpretations that go beyond what the law explicitly says, and sometimes even directly counter to the written law, as Justice William J. Brennan did in the Weber case. Professor Ronald Dworkin defended the Weber decision on grounds that the question of how Title VII should be interpreted cannot be answered simply by staring at the words Congress used. The verbal virtuosity of referring to simply staring at words apparently as the only alternative to adventurous reinterpretations, contrasts sharply with Holmes' statement about simply reading English intelligently. To Dworkin, the significance of the Weber decision was that it was another step in the court's efforts to develop a new conception of what equality requires in the search for racial justice. Why judges are to preempt such decisions and rule on the basis of their own new conceptions of social issues under the guise of interpreting the law, while going directly counter to what the law says, was a question not raised, much less answered. Saying that it is hard or impossible to discern what was meant by a law has often been a prelude to making decisions that ignore even the plainest meanings, as in the Weber case, in order to impose notions currently in vogue in elite circles as the law of the land. Dworkin and others have openly advocated as much, which makes their tactical agnosticism about intent a red herring. For those who do not intend to follow the original meaning of laws, the ease or difficulty of discovering that meaning is irrelevant, except as a distracting talking point. The Constitution was a very plainly written document, and when it used phrases like an establishment of religion, for example, it referred to something well known to people who had already lived under an established church, the Church of England. The prohibition against an establishment of religion had nothing to do with a wall of separation between church and state, which appears nowhere in the Constitution, but was a phrase from Thomas Jefferson, who was not even in the country when the Constitution was written. There was nothing esoteric about the phrase, an establishment of religion. For more than 100 years after the Constitution was written, it never meant that it was illegal to display religious symbols on government property, however much some people in later times might wish that this was what it meant, and however much some modern judges might be willing to accommodate that wish. Similarly, with phrases like due process or freedom of speech, which had a long history in British law before those same phrases were placed in the Constitution of the United States by people who had only recently ceased to be British subjects. They were not coining new phrases for new or esoteric concepts whose meaning judges would have to divine de novo. Judicial restraint involves not only upholding constitutional provisions and the provisions of legislation that are within the authority of Congress or the states, it also involves a reluctance to overrule prior court decisions. Without such a reluctance, laws could become so changeable with the changing personnel of courts that citizens would find it difficult to plan economic or other endeavors that take time to come to fruition, for it would be impossible to predict what the turnover of judges and their changing of laws would be in the meantime. Needless to say, this reluctance to overturn prior court decisions cannot be absolute, but must be a matter of cautious judgment. If some legal scholar today should publish an article or book showing convincingly that Marbury v. Madison was wrongly decided in 1803, no court today would be likely to overrule that decision, on which 2 centuries of precedents have been built, and under which all sorts of endeavors and commitments have been undertaken during those centuries, relying on the legal system that evolved in the wake of Marbury v. Madison. Yet, ironically, many of the same intellectuals who heartily supported the Warren Court's overturning of long-standing precedents during the 1950s and 1960s also bitterly condemned later and more conservative courts, which cut back on some of the precedents established by liberal justices, especially in decisions during the Warren Court era. Thus, under the headline, "The High Court Loses Restraint," a New York Times editorial reacted to the Lopez decision by saying, "In deciding that Congress lacks the power to outlaw gun possession within 1,000 feet of a school, the Supreme Court has taken an unfortunate historical turn and needlessly questioned previously settled law." Citing Justice Stephen Breyer, the Times emphasized the value of judicial restraint, defined by them as deferring to Congress when Congress showed a rational basis for finding an interstate commercial impact in its law. But to defer to those whose powers the Constitution specifically limited would be to make a mockery of those limitations. If Congress itself is to decide how far its powers extend, what purpose can there be in constitutional limitations on the power of Congress or of the federal government? Inconsistent as such reactions from the intelligentsia have been, when viewed as commentary on jurisprudence, these reactions are perfectly consistent when viewed as part of a results-oriented role for courts, since the intelligentsia clearly preferred the social results of the Warren Court's decisions to the social results of many decisions of later courts. But court decisions based on the social results preferred by judges, rather than on the law as written, have a number of adverse effects on law as a fundamental framework within which members of society can plan their own actions. The most obvious effect is that no one can predict what social results judges will turn out to prefer in the future, leaving even the most clearly written laws surrounded by a fog of uncertainty that invites increased litigation. The opposite of the results-oriented judge is the judge who will rule in favor of litigants that the judge may personally despise, if the law is on that side in that case. Justice Oliver Wendell Holmes, for example, voted in favor of Benjamin Gitlow in the 1925 case of Gitlow v. New York, and then said afterwards, in a letter to Harold Laski, that he had just voted for the right of an ass to drool about proletarian dictatorship. Likewise, Holmes dissented in Abrams v. United States in favor of appellants whose views he characterized in his judicial opinion itself as a creed that I believe to be the creed of ignorance and immaturity. As he told Laski, I loathed most of the things in favor of which I decided. Conversely, he could rule against litigants he personally viewed favorably. In another letter to Laski, Holmes said that he had to write a decision against a very thorough and really well-expressed argument by two colored men, one very black, that even in intonations was better than, I should say, the majority of white discourses that we hear. Holmes was not taking sides or seeking results, but applying the law. Results of results doctrines. Fundamental rights of individuals guaranteed by the Constitution of the United States and by legal traditions that go back even farther than the Constitution can be lost as a result of judicial rulings based on seeking particular social results in accordance with a prevailing vision. Insofar as the nebulous phrase social justice might have any discernible meaning, it seems to be that merely formal justice is not enough, but must be either supplemented or superseded by a kind of justice based on desirable social results. In any event, the rule of law, a government of laws and not of men, is the antithesis of results-oriented social justice, for the results are to be chosen according to the preferences of particular individuals, empowered to pick and choose desirable outcomes, rather than to apply rules known in advance to all and binding on both citizens and judges. Perhaps the ultimate in results-oriented law was that dispensed by representatives on mission in revolutionary France of the 1790s. These were particular members of the ruling convention, chosen to go about the country righting wrongs, empowered to act above all existing laws and authorities. They could make arrests, create revolutionary courts, conduct trials, erect guillotines. They could nullify, extend, or curtail the force of any law. They could issue decrees and proclamations on any subject. They could fix prices, requisition goods, confiscate property, collect taxes. They could purge any existing government body, or, if they chose, dissolve government bodies altogether, replacing them with committees of their own nomination. This was the ultimate in results-oriented law. While no one is advocating creating representatives on mission today, this is the general direction in which many are urging courts to move, by emphasizing results over rules. Particular judges have in fact appointed people, aptly called masters, to prescribe and oversee the policies and operations of prisons, schools, or other governmental institutions, and have even ordered state legislators to raise taxes. Going by results seems especially questionable in a court of law, which inherently lacks institutional mechanisms for monitoring what are in fact the results of judicial decisions, as their repercussions spread in all directions throughout society, as distinguished from how judges might have imagined what the results of their decision would be. Some results have in fact been the direct opposite of what results-based judicial decisions sought to do. Burdens of proof. Perhaps nothing is more fundamental to the American legal tradition than the requirement that the burden of proof be on the prosecution in criminal cases and on the plaintiff in civil cases. Yet the zeal for results has led to putting the burden of proof on the accused to prove their innocence in certain arbitrarily chosen classes of cases. This principle, or lack of principle, appeared in antitrust law before being applied in civil rights cases. The Robinson-Patman Act, for example, made price discrimination illegal, except under certain conditions. But once a prima facie case was made that different prices had been charged to different customers, the accused business then had to prove that the exceptions, such as cost differences in serving those customers, sufficient to justify the price differences, applied. Since the apparently simple word cost conceals complexities that can keep accountants, economists, and lawyers on both sides tied up in endless disputes, it may not be possible for either the accuser or the accused to prove anything conclusively. This means that the accused either loses those cases or else settles them out of court on whatever terms can be negotiated, given the impossibility of proving one's innocence. The more fundamental problem, however, is that the burden of proof has been put on the accused, contrary to centuries-old legal traditions applied in most other kinds of cases. The same results-oriented legal principle of putting the burden of proof on the accused reappeared later in court cases involving civil rights laws and policies. Here again, all it takes is a prima facie case, that is, an accusation not meeting even the civil law standard of preponderance of evidence, based simply on statistical underrepresentation of minorities or women in an enterprise's workforce, to put the burden of proof on the employer to show that discrimination is not the reason. No burden of proof whatever is put on those who presuppose an even or random distribution of achievements or rewards between racial or other groups in the absence of discrimination, despite vast amounts of evidence from both history and contemporary life of wholly disproportionate achievements among individuals, groups, and nations. An employer who has hired, paid, and promoted individuals without regard to race or sex can nevertheless find it either impossible or prohibitively expensive to disprove the accusation of discrimination. For example, the Equal Employment Opportunity Commission brought a sex discrimination case against the Sears department store chain in 1973, based solely on statistics, without being able to produce even one woman, either currently or previously employed in any of Sears' hundreds of stores across the country, to claim that she had personally been discriminated against. Yet this case dragged on through the courts for 15 years and cost Sears $20 million to litigate, before the Seventh Circuit Court of Appeals eventually ruled in Sears' favor. Since very few employers have that kind of money to spend on litigation, or can afford the negative publicity of such a damning charge hanging over them for so many years, most settle the cases out of court on whatever terms they can get, and these numerous settlements are then cited in the media and elsewhere as proof of how much discrimination there is. Again, all of this goes back to the practice of putting the burden of proof on the accused. Had the burden of proof been on the EEOC, the case might never have gotten as far as a trial in the first place, since the EEOC did not have even one woman who claimed that she had been discriminated against. All it had were statistics that did not fit the prevailing preconception that all groups would tend to be proportionally represented in the absence of discrimination. A similar case, one that went all the way up to the Supreme Court, again taking 15 years from the time of the original trial, produced a decision in favor of the accused employer that was subsequently overturned when Congress passed a new law restoring the burden of proof to the accused. In this case, the Wards Cove Packing Company, based in Washington State and Oregon, ran a fish canning operation up in Alaska. Since it recruited its management where the firm's main offices were located and recruited its canning workforce where the fish were caught, this led to a predominantly white management, based in Washington and Oregon, and a predominantly non-white workforce in Alaska. This statistical fact became the basis for charges of discrimination. The Ninth Circuit Court of Appeals upheld the charge of discrimination, but the Supreme Court overruled that decision and remanded the case for reconsideration. This set off a storm of criticism in the media and among academics. New York Times Supreme Court reporter Linda Greenhouse said that the ruling in Wards Cove v. Antonio shifted the burden of proof on a central question from employers to employees, charging job discrimination, expressing what happened in terms of social groups and social results, rather than in terms of legal principles and legal categories, plaintiffs and respondents, where the burden has for centuries been on plaintiffs to back up their accusations. According to Linda Greenhouse, the Wards Cove decision relieved employers of some of the burden of justifying practices that are shown to have a discriminatory impact. What Ms. Greenhouse chose to call discriminatory impact were employee demographics not matching population demographics, which is to say, real-world facts not matching the vision of the anointed. As in other contexts, the vision was taken as axiomatically true, so that statistical deviations from an even or random distribution of members of different groups in a business workforce could be taken as evidence of employer bias, a presumption which it was then the employer's responsibility to refute, or else be judged guilty of violating federal law. New York Times columnist Tom Wicker likewise accused the Supreme Court, in its radical Wards Cove decision, of overturning established law by having assigned the burden of proof to an employee who charged an employer with discriminatory hiring and employment practices. Previously, according to Wicker, the Supreme Court, in keeping with overall legal custom, had placed the burden on the party best able to show that the procedures at issue were fair and necessary, obviously the employer. Again, legal precedents were taken as preemptive, even though the particular precedent in this case, Griggs v. Duke Power, was not nearly as long-lived as Plessy v. Ferguson was when it was overturned by Brown v. Board of Education. Nothing in Wicker's discussion gave the readers any inkling that putting the burden of proof on the accused was a rare exception to legal traditions going back for centuries, an exception for certain classes of cases where social results were the primary concern and where the particular defendants, businesses, were out of favor with the intelligentsia, whether in antitrust cases under the Robinson-Patman Act or in civil rights cases. When Congress developed legislation to overturn the Ward's Cove decision and President George H.W. Bush threatened to veto, Tom Wicker said, "He threatens to make it easier for employers to discriminate and harder for employees, often members of minority groups, to get relief in court." The New York Times editorials made similar arguments. The Ward's Cove decision, it said, placed new, heavy burdens on civil rights plaintiffs. Again, there was no inkling given to the readers that what the New York Times called the heavy burdens on civil rights plaintiffs were the same burdens that most other plaintiffs in most non-civil rights cases had been carrying for centuries, on the basis of the legal principle that the accused are not required to prove their innocence. An op-ed column in the Washington Post likewise used a results criterion, complaining that the Ward's Cove decision was one making it far harder for plaintiffs to win such cases. An editorial in the Boston Globe likewise complained that the Ward's Cove decision was one making it virtually impossible for employees to win discrimination suits. Another Boston Globe editorial complained that the burden of proof now shifts to the plaintiff, as if this were an unusual place for the burden of proof to be. The response from academics was no less strident, no less filtered in its presentation of facts, and no less focused on results. Professor Ronald Dworkin of Oxford wrote of the brutal disparity between the races in the Ward's Cove case, which he called structural discrimination, and of the impossible burden put on plaintiffs. Professor Paul Gerwitz of Yale University said, "The Supreme Court has dealt body blows to two of the most important mechanisms for integrating the American workforce." Clearly, his focus was on social results, integrating the American workforce, not law. Professor Reginald Allen of the UCLA Law School was no less results-oriented and attributed the Ward's Cove decision to judges who simply dislike civil rights legislation. Professor Howard Eglett of the Chicago-Kent College of Law characterized the decision in the Ward's Cove case as a disingenuous revisionist treatment of the burden of proof. Another law professor, Alan Freeman of the State University of New York at Buffalo, likewise used the unworthy opponent notion, dubbing the justices who rendered the Ward's Cove decision reactionary apologists for the existing order who deserved contempt. Law professor Candace S. Kovacic-Fleischer of American University called for Congress to restore the normal allocation of burdens of proof. That is, if plaintiff proves an employment practice or practices caused a disparate impact, the burden then should shift to the employer to prove a business necessity for the practice. But this allocation of burdens of proof was normal only in civil rights cases, and in some antitrust cases, contrary to centuries of normal practice elsewhere in Anglo-American law. This burden of proof on employers was not mandated by the Civil Rights Act of 1964. On the contrary, in the congressional debates preceding passage of that act, Senator Hubert Humphrey and other leaders of the fight to pass this legislation explicitly repudiated the idea that statistical disparities would be enough to force an employer to try to prove that he was not discriminating. Senator Joseph Clark, another advocate for the Civil Rights Act of 1964, said that the Equal Employment Opportunity Commission established by that act must prove by a preponderance that the discharge or other personnel action was because of race, a preponderance of evidence, as in other civil cases, not a prima facie case, with the burden of proof then shifting to the employer, as later became the standard as a result of judicial rulings. It was the Supreme Court's Griggs v. Duke Power decision in 1971 which shifted the burden of proof to the employer, when there were hiring criteria which had a disparate impact on minority workers, in that case, a mental test or a high school diploma. The Griggs decision, less than 20 years old at the time of the Ward's Cove decision, was the established law from which Tom Wicker saw the Ward's Cove decision as a radical departure. Apparently, these journalists, academics, and their like-minded peers somehow just know that employer discrimination is the reason for statistical disparities, so apparently it is only a matter of making it easier for courts to reach that same conclusion. What this amounts to is that those members of society who are viewed unfavorably by the anointed are not to have the same rights as the general population, much less the privileges of those whom the anointed view favorably. The idea that law is about making it harder or easier for some selected segment of society to win lawsuits against some other selected segment of society runs through many, if not most, of the criticisms of the Ward's Cove decision by intellectuals. In short, they wanted results, and Congress gave it to them with the Civil Rights Restoration Act of 1991, which put the burden of proof back on the employer, unlike the original Civil Rights Act of 1964. Property rights. Nowhere have the actual results of results-oriented judicial rulings been more radically different from what was contemplated than in the case of property rights, which have long been a battleground between those with opposing social visions. As ideas of a living constitution to be applied to current conditions as judges see fit became dominant in the second half of the 20th century, property rights have been reduced to second-class status at best. As distinguished urban economist Edwin S. Mills put it, the courts have virtually abolished the Fifth Amendment as it applies to urban real estate. Property rights are seen in radically different terms by those with the tragic vision and those with the vision of the anointed. Those with the tragic vision of human flaws and failings see property rights as necessary limitations on the power of government officials to seize the belongings of the populace, whether for their own use or for dispersal as largesse to various constituencies whose political or financial support the politicians seek. Such actions by power holders were common in ancient despotisms and not unknown in modern democracies. Those who founded the United States of America and wrote the Constitution saw property rights as essential for safeguarding all other rights. The right to free speech, for example, would be meaningless if criticisms of the authorities could lead to whatever you owned being seized in retaliation. Economists have seen property rights as essential to 1. Keeping economic decision-making in the hands of private individuals, that is, out of the hands of politicians, and 2. Maintaining incentives for private individuals to invest time, talents, and resources in the expectation of being able to reap and retain the rewards of their efforts. However, those with the vision of the anointed, in which surrogate decision-makers are better equipped than others to make wise decisions, see property rights as obstacles to the achievement of various desirable social goals through government action. Property rights simply protect those individuals fortunate enough to own substantial property from the greater interests of society at large, according to those with this vision. Professor Lawrence Tribe of the Harvard Law School, for example, said that property rights represent simply an individual benefit to entrenched wealth. In other words, property rights are seen in terms of their individual results, rather than in terms of the social processes facilitated by a property rights system of economic decision-making. By contrast, free speech rights are almost never seen in such narrow terms, as special interest benefits for that very small proportion of the population who are professional writers, media journalists, or political activists. Instead, free speech rights are seen as rights essential to the functioning of the whole system of representative government, though property rights are seldom seen by intellectuals as similarly essential to the functioning of a market economy. Instead, property rights are readily disdained as special protections of the economically privileged, as they are by Professor Tribe and as they were before him by Roscoe Pound, Louis Brandeis, and many others. Those who take this dismissive view of property rights not only promote their own vision, but often also filter out the opposite vision of property rights, or distort it as just a defense of existing entrenched wealth, so that much of the public does not even learn what the issue is, making the question of how to resolve the issue moot. Once property rights are reduced by verbal virtuosity to simply a special benefit for a privileged few, these rights are then seen as less important than benefits to the larger society. It follows from this that property rights must often give way in clashes with other rights, when the issue is posed as property rights versus human rights. Such arguments, however, make sense only within the framework of the vision of the anointed. Otherwise, there is no clash between property rights and human rights because, 1. Property itself has no rights, and 2. Only human beings have rights. Any clash is between different sets of human beings. Property rights are legal barriers to politicians, judges, or bureaucrats arbitrarily seizing the assets of some human beings to transfer these assets to other human beings. Those who see surrogate decision-makers with both the right and the duty to make income distribution more equal, or more just, see property rights as a barrier that should not stand in the way of that overriding goal. As the ideas of progressive-era intellectuals became dominant in the law schools and in the courts during the second half of the 20th century, property rights have been eroded by judicial decisions, and the ability of government officials to override the rights of property owners has been justified on grounds of a greater public interest, supposedly for the benefit of the less fortunate. However, here as elsewhere, because certain notions fit the vision, there has been remarkably little attention paid to whether they also fit the facts. In other words, the notion that an erosion of property rights benefits those with limited incomes, who lack any substantial property, is taken as axiomatic, rather than as a hypothesis to be tested empirically. The implicit assumption that the weakening of property rights would benefit the less fortunate, at the expense of the more fortunate, has turned out to be, in innumerable cases, the very opposite of what has in fact happened. Given a freer hand in confiscating property, government officials at all levels have for decades promoted massive demolitions of working-class and low-income neighborhoods in urban renewal programs that replaced these neighborhoods with more upscale housing, shopping malls, and other attractions for the more affluent members of society. The larger amounts of taxes that such redeveloped areas would pay provided obvious incentives for political leaders to benefit themselves at the expense of the displaced population. These displaced populations have been predominantly low-income and minority groups, primarily blacks. The ultimate consummation of the legal trends toward reducing property rights as restrictions on government action came with the 2005 case of Kelo v. New London, in which the Constitution's provision that private property could be taken for public use was expanded to mean that such property could be taken for a public purpose. While a public use would include such things as the government's building a reservoir, a bridge, or some other such facility, public purpose could mean almost anything. And in the Kelo case, it meant confiscating people's homes to turn the property over to developers who would build various upscale facilities. An even more direct benefit to the affluent and the wealthy, at the expense of people of low or moderate incomes, has resulted from the ever greater scope allowed government officials to override property rights in the name of open space, smart growth, and other forms of arbitrary building restrictions, politically packaged under a variety of rhetorically attractive labels. Banning the building of homes or other structures in or around upscale communities greatly reduces the ability of less affluent people to move into such communities, both because of the reduction in the physical supply of land for housing and because of skyrocketing housing prices resulting from vastly increased land prices when the supply of buildable land has been artificially restricted. The doubling, tripling, or more of housing prices in the wake of building restrictions does not adversely affect those already living in upscale communities, except for renters, but in fact benefits homeowners by raising the value of their own homes in an artificially restricted market. The arbitrary powers of planning commissions, zoning boards, and environmental agencies to restrict or forbid the use of private property in ways they choose to disapprove gives them leverage to extract concessions from those who seek to build anything under their jurisdiction. These concessions may be extracted either illegally in the form of direct personal bribes or legally through forcing the property owner to contribute part of the property to the local jurisdiction. In the town of San Mateo, California, for example, approval of a housing development was made contingent on the builders turning over to local authorities a 12-acre plot on which the city will build a public park, contributing $350,000 toward public art, and selling about 15% of the homes below their market value. Chief Justice John Marshall said that the power to tax is the power to destroy. The power of arbitrary regulation is the power to extort, just as is the power to put the burden of proof on the accused. In the case of housing, the concessions extorted from builders are ultimately paid for by people who buy or rent the homes or apartments that they build. The erosion of property rights permitted by courts affect even people who own no property but who have to pay more to rent, or who are unable to afford to either rent or buy in communities where housing prices have been artificially inflated by land use restrictions to levels unaffordable to any but the affluent or wealthy, establishing a cordon sanitaire around upscale communities, keeping out people of moderate or low incomes. Whatever the results being sought by those who urged a weakening of property rights, These are the results actually achieved. Even low or moderate income people already living within communities that override property rights with arbitrary building restrictions can be forced out as rent rises steeply. In San Francisco, for example, the black population has been cut in half since 1970, and in some other coastal California counties, it has not been uncommon for the black population to decline by 10,000 or more just between the 1990 and 2000 censuses, even when the total population of these counties was growing. One of the many problems of results-oriented judicial decisions is that actual results cannot be confined to the particular results that judges had in mind, and that other results are seldom predictable. Given legal precedents, these results-oriented decisions are seldom reversible, no matter how far the actual results differ from what was expected. Burdens of proof and property rights are just two examples among many. Crime. The vision of crime, common among intellectuals, goes back at least 2 centuries, but it gained the ascendancy in practice only during the second half of the 20th century. Louis Brandeis's claim that modern social science has raised the issue whether the surrounding community was not as much responsible for theft as the thief himself, ignored the fact that blaming crime on society was a common notion among those with the vision of the anointed as far back as the 18th century, which is to say, before modern social science, though these earlier speculations antedated the practice of wrapping themselves in the mantle of science. The vision of the anointed has long de-emphasized punishment and emphasized prevention by getting at the social root causes of crime beforehand and by rehabilitation of criminals afterwards. Subsidiary themes in this vision include mitigation of personal responsibility on the part of criminals as a result of unhappy childhoods, stressful adulthoods, or other factors assumed to be beyond the control of the individual. Conflicting theories of crime can be debated endlessly, and no doubt will be, as will many other questions expanded to unanswerable dimensions. What is relevant here, however, is what the evidence of actual results has been from the ascendancy and pervasive prevalence of the intellectual's vision of crime, and what the intellectual's reactions have been to that evidence. In the United States, where murder rates had been going down for decades, and were in 1961 less than half of what they had been in 1933, the legal reforms of the 1960s, applying the ideas of intellectuals and widely applauded by the intelligentsia, were followed almost immediately by a reversal of this long downward trend, with the murder rate doubling by 1974. In Britain, the ascendancy of the same vision of crime was followed by similarly sudden reversals of previous downward trends in crime rates. As one study noted, scholars of criminology have traced a long decline in interpersonal violence since the late Middle Ages, until an abrupt and puzzling reversal occurred in the middle of the 20th century. And a statistical comparison of crime in England and Wales with crime in America, based on 1995 figures, discovered that for 3 categories of violent crime, assaults, burglary, and robbery, the English are now at far greater risk than Americans. The abruptness of the reversal of a long downward trend in crime rates, on both sides of the Atlantic, greatly reduces the likelihood that the results were due to the kinds of complex social changes which take years to gradually unfold. But within a relatively short span of time, legislation, court decisions, and government policy changes in both Britain and the United States greatly reduced the likelihood that a criminal would be convicted and punished for a given crime, reduced the severity of the punishment for those who were punished, and simultaneously reduced the ability of law-abiding citizens to defend themselves when confronted with a criminal, or to be armed to deter criminal attacks. In Britain, the anti-gun ideology is so strong that even the use of toy guns in self-defense is opposed. Merely threatening to defend oneself can also prove illegal, as an elderly lady discovered. She succeeded in frightening off a gang of thugs by firing a blank from a toy gun, only to be arrested for the crime of putting someone in fear with an imitation firearm. Use of a toy gun for self-defense during a housebreak is also unacceptable, as a householder found who had detained with an imitation gun 2 men who were burgling his home. He called the police, but when they arrived, they arrested him for a firearms offense. British intellectuals have long been zealous advocates of gun control. A 1965 article in the New Statesman declared that firearms in private hands serve no conceivable civilized purpose, that the possession or use of pistols or revolvers by civilians was something that cannot be justified for any purpose whatsoever. A 1970 article in the same publication urged laws banning all firearms, whether concealed or not, from the entire civilian population. Like so many ideas among the intelligentsia, the zeal for gun control laws has defied years of mounting evidence of their futility and counterproductive consequences. For example, a scholarly study in 2001 found that the use of handguns in crime rose by 40% in the 2 years after such weapons were banned in the UK. An earlier study found, in homicide involving organized crime and drugs, no legally owned firearms were used at all, but 43 illegal ones were. Other studies likewise indicated that, in England as in the United States, laws against owning guns had no discernible effect on people who make their livings by breaking laws. In 1954, there were only 12 cases of robbery in London in which a firearm was used, and on closer inspection, 8 of these were only supposed firearms. But armed robberies in London rose from 4 in 1954, when there were no controls on shotguns and double the number of licensed pistol owners, to 1,400 in 1981, and to 1,600 in 1991. In 1998, a year after a ban on virtually all handguns, gun crime was up another 10%. As gun control laws were made ever tighter in Britain toward the end of the 20th century, murder rates rose by 34%, while murder rates in Canada and the United States were falling by 34% and 39%, respectively. Murder rates in France and Italy were also falling by 25% and 59%, respectively. Britain, with its strong anti-gun ideology among the intellectual and political elites, was an exception to international trends. Meanwhile, Americans' purchases of guns increased during this same period, gun sales surging to a peak in 1993 of nearly 8 million small arms, of which 4 million were handguns. Far from leading to more murders, this was a period of declining murder rates in the United States. Altogether, there were an estimated 200 million guns in the United States, and rates of violent crime were lowest where there was the highest incidence of gun ownership. The same has been true of Switzerland. Yet none of this has caused second thoughts about gun control among either the American or British intelligentsia. In Britain, both ideology and government policy have taken a negative view of other measures of self-defense as well. Opposition to individual self-defense by law-abiding citizens extends even beyond guns or imitation guns. A middle-aged man attacked by 2 thugs in a London subway car unsheathed the sword blade in his walking stick and slashed at one of them, and was arrested, along with his assailants, for carrying an offensive weapon, even putting up barbed wire around a garden and its shed, that had been broken into several times, was forbidden by local authorities, fearful of being sued if a thief injured himself while trying to break in. That such a lawsuit would be taken seriously is another sign of the prevailing notions among British officials. The root causes theory of crime has likewise remained impervious to evidence on both sides of the Atlantic. In both the United States and England, crime rates soared during years when the supposed root causes of crime, poverty and barriers to opportunity, were visibly lessening. As if to make a complete mockery of the root causes theory, the ghetto riots that swept across American cities in the 1960s were less common in southern cities, where racial discrimination was still most visible, and the most lethal riot of that era occurred in Detroit, where the poverty rate among blacks was only half that of blacks nationwide, while the home ownership rate among blacks was higher than among blacks in any other city, and the black unemployment rate in Detroit was 3.4%, which was lower than the national unemployment rate among whites. Urban riots were most numerous during the administration of President Lyndon Johnson, which was marked by landmark civil rights legislation and a massive expansion of social programs called the War on Poverty. Conversely, such riots became virtually non-existent during the 8 years of the Reagan administration, which de-emphasized such things. It would be hard to think of a social theory more consistently and unmistakably belied by the facts, but none of this has made a dent on those who have espoused the root causes theory of crime or the general social vision behind it. The United States was not the only country in which the supposed root causes of crime showed no correlation with the actual crime rate. Britain was another. Against prodigious odds, violent crime plummeted during the 19th century. From mid-century up to the First World War, reported assaults fell by 71%, woundings by 20%, and homicides by 42%. The age was cursed with every ill modern society pegs as a cause of crime: wrenching poverty alongside growing prosperity, teeming slums, rapid population growth and dislocation, urbanization, the breakdown of the working family, problematic policing, and, of course, wide ownership of firearms. Even the most blatant facts can be sidestepped by saying that the causes of crime are too complex to be covered by a simplistic explanation. This verbal tactic simply expands the question to unanswerable dimensions, as a prelude to dismissing any explanation not consonant with the prevailing vision as simplistic, because it cannot fully answer the expanded question. But no one has to master the complexities of Newton's law of gravity to know that stepping off the roof of a skyscraper will have consequences. Similarly, no one has to unravel the complexities of the innumerable known and unknown reasons why people commit crimes to know that putting criminals behind bars has a better track record of reducing the crime rate than any of the complex theories or lofty policies favored by the intelligentsia. Expanding the question to unanswerable dimensions, and then deriding any unwelcome answer as simplistic, is just one of the ways that intellectuals' rhetorical skills have been deployed against facts. As another example, to demand a return to law and order was long stigmatized as a sign of covert racism, since the crime rate among blacks was higher than among whites. As noted in Chapter 2, a retired New York police commissioner who tried to tell a gathering of judges of the dangerous potential of some of their rulings was literally laughed at by the judges and lawyers present. In short, theory trumped experience, as the vision has so often trumped facts, and the benighted were treated as not even worth taking seriously by the anointed. Similar attitudes have accompanied the same vision in Britain, where much of the media, academia, and the intelligentsia in general, as well as university-trained public officials, treat the public's complaints about rising crime rates and demands for some serious sanctions against criminals as mere signs of the public's lesser understanding of the deeper issues involved. On both sides of the Atlantic, the elites put their emphasis on the problems experienced by the people who commit crimes, and on how various social programs to solve those problems will be the real solution to the crime problem in society. In the United States, even such things as prompt collection of garbage has been depicted by New York Times columnist Tom Wicker as part of the social justice needed to stem crime. No amount of hard evidence has been able to burst through the sealed bubble of this elite vision in Britain. On the contrary, data that contradict that vision have been suppressed, filtered out, or spun rhetorically by British officials, so much so that the British magazine The Economist reported widespread distrust of official figures, while the British media have tried to make the public feel guilty for the imprisonment of those relatively few criminals who are in fact imprisoned. Typical of the disdain for public complaints has been the response, or non-response, to the experiences of people living in neighborhoods in which institutions for released criminals have been placed. They spoke of a living nightmare brought about by the non-stop crime, intimidation, vandalism, and harassment inflicted on them by their criminal residents. All spoke of their total failure to get local politicians, MPs, criminal justice officials, police, or indeed anyone to take any notice of their desperate situation. For many of those with the vision of the anointed, a wide difference between the beliefs and concerns of the population at large and the beliefs and concerns of themselves and like-minded peers is not a reason for reconsideration, but a source of pride in being one of the anointed with a higher vision. Meanwhile, in the United States, after many years of rising crime rates had built up sufficient public outrage to force a change in policy, rates of imprisonment rose, and crime rates began falling for the first time in years. Those with the vision of the anointed lamented the rising prison population in the country, and, when they acknowledged the declining crime rate at all, confessed themselves baffled by it, as if it were a strange coincidence that crime was declining as more criminals were taken off the streets. In 1997, for example, New York Times writer Fox Butterfield wrote under the headline, "Crime keeps on falling, but prisons keep on filling," as if there was something puzzling about this. It has become a comforting story. For 5 straight years, crime has been falling, led by a drop in murder. So why is the number of inmates in prisons and jails around the nation still going up? Already, California and Florida spend more to incarcerate people than to educate their college-age populations. The irrelevant comparison of prison costs versus college costs became a staple of critics of imprisonment. A New York Times editorial in 2008 was still repeating this argument in its laments about a growing prison population. After 3 decades of explosive growth, the nation's prison population has reached some grim milestones. More than 1 in 100 American adults are behind bars. 1 in 9 black men, ages 20 to 34, are serving time, as are 1 in 36 adult Hispanic men. Nationwide, the prison population hovers at almost 1.6 million, which surpasses all other countries for which there are reliable figures. The 50 states last year spent about $44 billion in tax dollars on corrections, up from nearly $11 billion in 1987. Vermont, Connecticut, Delaware, Michigan, and Oregon devote as much money or more to corrections as they do to higher education. This was by no means the first time that rising rates of imprisonment were denounced in the New York Times. Years earlier, in 1991, New York Times columnist Tom Wicker said that crimes of violence have not decreased at all in the wake of rising levels of imprisonment, a claim that later statistics disproved, and urged shorter sentences, as well as improved educational and vocational services and drug treatment in prisons, and deplored panicky public fears and punitive public attitudes. Here, as with many other issues, the differing views of others were verbally reduced to mere emotions, panicky, rather than arguments that had to be analyzed and answered with facts. Within prisons themselves, the changed public attitudes toward prisoners in the United States were reflected in tougher measures against inmates who caused trouble. Assaults at Folsom dropped 70% in 4 years, from 6.9 for every 100 inmates in 1985 to 1.9 in 1989. Despite a steep rise in the nation's prison population in the 1980s, and despite occasional frightening outbreaks of violence like the one at Rikers Island in New York this summer, stories like Folsom's are being repeated all over the country. Prison officials, emboldened by a public mood that brooks no patience for criminals, say they have taken greater control of their institutions. Hard evidence about the effectiveness of asserting law enforcement authority, both in prison and outside, made no discernible difference to those with the vision of the anointed, either in the United States or in Britain. Yet an inverse correlation between imprisonment rates and crime rates could also be found in Australia and New Zealand, where a trend back toward more imprisonment was likewise accompanied by a decline in crime rates. The British intelligentsia have been no more impressed with facts than their American counterparts. The British media and academia abound with people opposed to imprisonment. The Economist magazine, for example, referred to America's addiction to incarceration, the reduction of opposing views to mere emotions being a pattern among the intelligentsia on both sides of the Atlantic. A probation officer's revealing account of the difference between vision and reality derived from his listening to his car radio while driving to work at a prison. On the radio, a government minister was being questioned by an interviewer. A well-known presenter introduced his question to a minister with the statement, "We all know that we send too many people to prison in this country." This introductory remark was made with great assurance and confidence. It conveyed the belief that this statement was something everyone knew and was beyond question. Yet, as I listened, I knew I was driving to a prison which, despite its huge catchment area, it served magistrates' courts districts from several parts of the country, was only half full. What is more, this institution took the 17 to 20-year-old offender age group, known to be highly prolific offenders. If any prison was going to be full, it should have been ours. Yet for some years, it had only ever been half full at the most, and was often far less occupied than that. At the very time that the Today program was confidently misleading the public over the numbers of offenders being given custodial sentences, the Home Office were drawing up plans to close our prison and many more besides. In Britain, as in the United States, it is often taken as axiomatic that prisons are ineffective, as The Economist put it. The reason? They may keep offenders off the streets, but they fail to discourage them from offending. 2/3 of ex-prisoners are rearrested within 3 years of being released. By this kind of reasoning, food is ineffective as a response to hunger because it is only a matter of time after eating before you get hungry again. Like many other things, incarceration only works when it is done. The fact that criminals commit crimes when they are no longer incarcerated says nothing about whether incarceration is effective in reducing crime. The empirical question of the effect on the crime rate of keeping more criminals off the streets was not even considered in this sweeping dismissal of prisons as ineffective. The ideology of alternatives to incarceration is not only a shibboleth among the British intelligentsia, but is also backed up by the self-interest of government officials in reducing expenditures on prisons. Although statements about how much it costs to keep a prisoner behind bars, as compared to the cost of keeping a student at some expensive college, have become staples in arguments against incarceration, the relevant comparison would be between the cost of keeping someone in prison versus the costs of letting a career criminal loose in society. In Britain, the total cost of the prison system per year was found to be £1.9 billion, while the financial cost alone of the crimes committed per year by criminals was estimated at $60 billion. In the United States, the cost of incarcerating a criminal has been estimated as being at least $10,000 a year less than the cost of turning him loose in society. In Britain, the anti-incarceration ideology is so strong that only 7% of convicted criminals end up behind bars. In December 2008, London's Daily Telegraph, in its online publication, telegraph.co.uk, reported, "Thousands of criminals spared prison go on to offend again." It said, "More than 21,000 offenders serving non-custodial sentences committed further crimes last year, casting doubt over Labour's pledge to make the punishments a tough alternative to jail." The transformation of Britain wrought by the triumph of the vision of the anointed may be summarized by noting that Britain, which had long had one of the lowest crime rates in the world, had by the end of the 20th century seen its crime rate in most categories rise several-fold, and eventually surpass that of the United States. As a young man visiting Britain shortly after the Second World War, Lee Kuan Yew was so impressed with the orderly and law-abiding people of London that he returned to his native Singapore, determined to transform it from the poverty-stricken and crime-ridden place that it was at the time. Later, as a leader of the city-state of Singapore for many years, Lee Kuan Yew instituted policies that resulted in Singapore's rise to unprecedented levels of prosperity, with an equally dramatic fall in crime. By the beginning of the 21st century, the crime rate per 100,000 people in Singapore was 693, and in Britain was over 10,000. Singapore had, in effect, gone back in time to policies and methods now disdained by the intelligentsia as outmoded and simplistic. In light of the fact that a wholly disproportionate amount of crime is committed by a relatively small segment of the population, it is hardly surprising that putting a small fraction of the total population behind bars has led to substantial reductions in the crime rate. However, that is not sufficient for those who take a cosmic view of justice and lament that some people, through no fault of their own, are born into circumstances far more likely to result in criminal behavior than the circumstances into which others are born. While those with this vision tend to regard those circumstances as economic or social, the same injustice, as viewed from the same cosmic perspective, is involved when people are born into cultural circumstances that are more likely to lead them into crime. Yet, far from taking on the daunting task of trying to change cultures or subcultures, many of the intelligentsia are adherents of the multicultural ideology, according to which cultures are all on a plane of equality, so that trying to change some cultures would be an unwarranted intrusion, cultural imperialism, as it were. Like so many other nice-sounding notions, the multicultural ideology does not distinguish between an arbitrary definition and a verifiable proposition. That is, it does not distinguish between how one chooses to use words within one's own mind and the empirical validity of those words outside in the real world. Yet consequences, for both individuals and society, follow from mundane facts in the real world, not from definitions inside people's heads. Empirically, the question whether or not cultures are equal becomes, equal in what demonstrable way? That question is seldom, if ever, asked, much less answered, by most of the intelligentsia. In addition to claims that crime can be reduced by getting at its supposed root causes, many among the intelligentsia also advocate rehabilitation of criminals, anger management, and other therapeutic approaches to reducing crime, not simply as a supplement to traditional imprisonment, but also as a substitute. Like other alternatives to incarceration, these are not treated as hypotheses to be tested, but as axioms to be defended. No matter how high the rate of recidivism among those who have been through rehabilitation programs, or how much violence continues to be committed by those who have been in anger management programs, these notions are never considered to be refuted. Between the suppression of evidence by officials and its evasion through the verbal virtuosity of the intelligentsia, these theories can seldom be defeated by mere facts. By the same token, none of the traditional methods of crime control that have been supplanted by newer and more fashionable methods can be resurrected on the basis of factual evidence. The very mention of Victorian ideas about society in general, or crime control in particular, is virtually guaranteed to evoke a sneer from the intelligentsia. The fact that the Victorian era was one of a decades-long decline in alcoholism, crime, and social pathology in general, both in Britain and in the United States, in contrast to more modern ideas with the opposite results in both countries, carries virtually no weight among the intelligentsia, and such facts remain largely unknown among those in the general public who depend on either the media or academia for information. The fact that ordinary common-sense measures against crime are effective remains a matter of surprise among many of the intelligentsia, After decades of controversy over ways of reducing crime, in 2009 such news rated a headline in the San Francisco Chronicle. Homicides plummet as police flood tough areas. The account began, San Francisco's homicide total for the first half of 2009 hit a 9-year low, falling more than 50% from last year, a drop that police officials attribute to flooding high crime areas with officers and focusing on the handful of people who commit most of the crimes. A few intellectuals, James Q. Wilson being the most prominent, have bucked the tide when it comes to crime, but most of their work consists of showing what is wrong with the work of the far more numerous intellectuals whose theories of crime and prescriptions for crime control have been pervasive and have, in practice, led only to rising crime rates. The net cost of intellectuals to society as regards crime would include not only the vast sums of money lost by the general public, greatly exceeding the cost of keeping criminals behind bars, but also the impact of policies based on their theories on the lives of ordinary law-abiding citizens, brutalized by violence, demoralized by fear, or cut short by criminals or rioters. If it were possible to quantify the cost of turning the theories of the intellectuals into the law of the land, the total cost would undoubtedly be enormous, just as regards crime. Chapter 7. Intellectuals and War. Bad ages to live through are good ages to learn from. Eugen Weber. Like virtually everyone else, intellectuals generally prefer peace to war. However, as already noted in Chapter 4, there are some very fundamental differences in ideas on how to prevent wars. Just as the vision of crime prevention among intellectuals goes back at least as far as the 18th century, so too does their vision of war and peace. In contrast to the tragic vision, which sees military strength as the key to deterrence, the vision of the intellectuals has long been one that relies on international negotiations and/or disarmament agreements to avoid wars. Regardless of intellectuals' vision of war in general, there are no wars in general. The real question is, how have intellectuals reacted to particular wars, or particular threats of war, at particular times? Since our focus is on intellectuals from an era when their influence has had a major impact on public opinion and government policies, that confines the question largely to intellectuals in Western nations in recent times. Within this era, intellectuals have sometimes been strong supporters of particular wars and sometimes strong opponents of other wars. There are elements of their vision consistent with either position. Sometimes the position of intellectuals for or against a particular war seems to have been a matter of whether the time was one of a long period of peace, or one in which the horrors of war had been a recent and indelible memory. The period leading up to the First World War, for example, was one in which the United States had not experienced a major war involving a large part of its population for more than a generation. In Europe, it had been nearly a century since the Napoleonic Wars ravaged the continent. In Germany, during the mid-1890s, 2 decades since the Franco-Prussian War, many intellectuals, including university professors, supported the Kaiser's government in its plans to build a big and expensive navy as part of a more aggressive international stance in general, even though Germany was a land power, with few overseas interests to protect. In such a time, it was easy for many intellectuals and others to think of war in the abstract, and to find, in its excitement and sense of social cohesion and national purpose, positive virtues, while its devastating human costs receded into the background of their thoughts. Even those mindful of the carnage and devastation of war could speak, as William James did, of a need for the moral equivalent of war, to mobilize people behind a common purpose and common aspirations. It was part of a long-standing assumption among many intellectuals of a dirigiste orientation that it is the role of third parties to bring meaning into the lives of the masses. As already noted, the vision of the anointed is a vision of intellectual and moral elites being surrogate decision-makers, imposing an overarching common purpose to supersede the disparate and conflicting individual purposes and individual decisions of the population at large. War creates a setting in which this vision can flourish. It also creates many other things, so that the net effect is very much influenced by the conditions of the times. In the 20th century, the First World War presented both an opportunity for the vision of the anointed to flourish, and later, after the fact, a devastating reminder of the horrors of war which had been ignored or underestimated. The post-war backlash against those horrors then set in motion a radically different view of war, leading to widespread pacifism among intellectuals. But even though many intellectuals radically changed their view of war within a relatively few years, What they did not change was their conviction that they, as the anointed, were to continue to act as guides to the masses and to take the lead in promoting government policies in line with their new anti-war vision. These various periods in the history of intellectuals' pro-war and anti-war visions need to be examined individually. The First World War. The First World War was a shock to many people, in many ways. Nearly a century without a major war on the European continent had lulled some into a comfortable feeling that European civilization had somehow left war behind as a thing of the past. Many on the far left believed that international working-class solidarity would prevent the workers of different countries from killing each other on the battlefields, supposedly for the benefit of their exploiters. In countries on both sides, generations that had no experience with war marched off to war with great public fanfare, exhilaration, and a sense of assurance that it would all be over, victoriously, in a relatively short time. Few had any idea of how modern technology would make this the most lethal and ghastly war the world had yet seen. For both soldiers and civilians alike, how many of the survivors across the continent of Europe would end up hungry or starving amid the ruins and rubble of war, or how many centuries-old empires would be shattered into oblivion by the war, much less what a monstrous new phenomenon, totalitarianism, would be spawned in the chaotic aftermath of that war. Intellectuals were among the many whose illusions would be brutally smashed by the catastrophes of the First World War. The pre-war era. At the beginning of the 20th century, the only war that most Americans had experienced was the Spanish-American War, in which the overwhelming power of the United States had quickly driven Spain from its colonies in Cuba, Puerto Rico, and the Philippines. Looking back at the Spanish-American War, Woodrow Wilson approved of the annexation of Puerto Rico by President William McKinley, saying of those annexed, "They are children and we are men in these deep matters of government and justice." Wilson disdained what he called the anti-imperialist weepings and wailings of critics of these actions. As for Theodore Roosevelt, even before becoming president, he was not only a supporter of the Spanish-American War, but a major participant. It was, in fact, his own military exploits in that war, as a leader of the men called Rough Riders, that first made him a national figure. This was an era when imperialism was seen as an international mission of America to spread democracy, and as such was supported by many Progressive-era intellectuals. The Progressive-era classic, The Promise of American Life, by New Republic editor Herbert Croly, argued that most Asians and Africans had little chance of developing modern democratic nations without the superintendence of Western democracies. He said, "The majority of Asiatic and African communities can only get a fair start politically by some such preliminary process of tutelage, and the assumption by a European nation of such a responsibility is a desirable phase of national discipline and a frequent source of genuine national advance. More generally, a war waged for an excellent purpose contributes more to human amelioration than a merely artificial peace," according to Croly. However much intellectuals have traditionally been opposed to imperialism for the benefit of economic interests, military interests, territorial expansion, or the self-aggrandizement of reigning political leaders, interventions in other countries in the absence of these factors, and for ideological reasons, have by no means been so universally condemned by the intelligentsia. Indeed, the complete absence of any national interest in a particular intervention has often been treated by intellectuals as exempting that intervention from the moral condemnation applied to other cases of imperialism. Seen in this light, substantial support from intellectuals of the Progressive era for American military interventions in poor countries, from which no serious material benefit could be expected, was quite understandable at a time when those interventions posed virtually no danger to the United States, and when a long preceding era of peace allowed the brutal realities of war to recede into the background in people's minds. In such special circumstances, imperialism was simply an extension across national boundaries of the notion that the special wisdom and virtue of the anointed should be guiding other people's lives. Famed editor William Allen White said, "Only Anglo-Saxons can govern themselves," and declared, "It is the Anglo-Saxon's manifest destiny to go forth as a world conqueror." Crusading progressive journalist Jacob Riis, who knew Theodore Roosevelt from the days when TR was a police commissioner in New York City, said, "Cuba is free, and she thanks President Roosevelt for her freedom." He also said, "I am not a jingo, but when some things happen I just have to get up and cheer. The way our modern American diplomacy goes about things is one of them." Willard D. Straight, who financed the founding of the New Republic magazine, and Herbert Croly, its first editor, both supported the imperial adventurism of Theodore Roosevelt. Croly declared that the forcible pacification of one or more such centers of disorder in the Western Hemisphere was a task for the United States, which has already made an effective beginning in this great work, both by the pacification of Cuba and by the attempt to introduce a little order into the affairs of the turbulent Central American republics. Croly saw no contradiction between the principles behind progressive domestic reforms and progressive support for foreign adventurism. That war and its resulting policy of extraterritorial expansion, so far from hindering the process of domestic amelioration, availed, from the sheer force of the national aspirations it aroused, to give a tremendous impulse to the work of national reform, and it indirectly helped to place in the presidential chair the man who, as I have said, represented both the national idea and the spirit of reform. John Dewey likewise saw war as constraining the individualistic tradition which he opposed, and establishing the supremacy of public need over private possessions. As for Woodrow Wilson, not only was he a believer in the rightness of McKinley's intervention in Spain's colonies, as president he ordered a number of military inventions of his own in Latin America before he made his biggest and most fateful intervention in the First World War raging in Europe. America at War. The ostensible cause of the entry of the United States into the stalemated carnage in Europe during the First World War was German submarines sinking passenger ships which had American passengers on board. But these were ships entering a war zone in which both the British and the Germans were maintaining naval blockades, the former with surface ships and the latter with submarines, and each with the intention of denying the other both war materiel and food. Moreover, the most famous of these sinkings by German submarines, that of the Lusitania, was of a British passenger ship that was, years later, revealed to have been secretly carrying military supplies. By the very nature of submarine warfare, these undersea craft could not give the warnings and pauses to let crews and passengers disembark before sinking passenger ships. This was especially so when many civilian ships entering war zones were armed, and when the advent of radio meant that any ship that had been warned could immediately summon warships to the scene to sink the submarine. The sudden surprise attacks of submarines, the only way they could operate without endangering themselves, added to the shock at the loss of innocent lives. But it was the insistence by Woodrow Wilson on a right of Americans to sail safely into blockaded ports during wartime which created the setting for these tragedies. He had on his side international conventions created before the submarine became a major factor in naval warfare. Eventually, he made Germany's submarine warfare against ships sailing to enemy ports the centerpiece of his appeal to Congress in 1917 to declare war on Germany. Whether that was Wilson's real reason for wanting war, or instead a convenient occasion for launching an international ideological crusade, is not clear, especially in view of the war message itself and subsequent statements and actions by President Wilson. Woodrow Wilson could not resist inserting into his war message to Congress criticisms of the autocratic nature of the German government, and a reference to heartening things that had been happening within the last few weeks in Russia, with the overthrow of the Tsar's autocratic government there. This was in keeping with his more famous characterization of the First World War as a war in which the world must be made safe for democracy, and his later post-war efforts to remake nations and empires in the image of his vision of what they should be like, which was a continuation on a larger scale of his interventionist policies in Latin America. Before the war was over, Wilson was publicly demanding the destruction of every arbitrary power anywhere that can separately, secretly, and of its single choice disturb the peace of the world. This was not just idle rhetoric. Wilson sent a note to Germany demanding that Kaiser Wilhelm abdicate. Like many other intellectuals, Wilson depicted actions taken without material motives to be somehow on a higher moral plane than actions taken to advance the economic interests of individuals or the territorial interests of nations, as if sacrificing countless lives to enable the anointed to play a historic role on the world stage in furthering their vision was not at least as selfish and calloused as seeking material ends would be. In a later time, Adolf Hitler would say, "I have to attain immortality, even if the whole German nation perishes in the process." Woodrow Wilson was too moralistic to say such a thing, but given the power of human rationalization, the net difference in this respect may not have been great. Sinking the blood and treasure of a nation for ideological aggrandizement was equated with idealism by many intellectuals of the time, as well as in later times. Moreover, like many other issues addressed by intellectuals, Woodrow Wilson's policies and actions have not been judged nearly as often by their actual empirical consequences as by how well their goals fit the vision of the anointed. Among the progressives and others on the left who rallied to President Wilson's war efforts were New Republic editor Herbert Croly, John Dewey, Clarence Darrow, Upton Sinclair, Walter Lippmann, John Spargo, and George Creel, a former muckraker who spearheaded the wartime propaganda efforts of the Wilson administration. Dewey, for example, declared, "I have been a thorough and complete sympathizer with the part played by this country in this war, and I have wished to see the resources of this country used for its successful prosecution." Since Wilson had been, for much of his adult life, a quintessential academic intellectual, it is hardly surprising that his words as president repeatedly found resonance among many other intellectuals and evoked lavish praise from them. For example, one of Woodrow Wilson's speeches about the right of self-determination of peoples in 1916 elicited these responses. The president of Williams College, for instance, compared it to the Gettysburg Address. Walter Lippmann, using the Monroe Doctrine as his point of reference, wrote, "In historic significance, it is easily the most important diplomatic event that our generation has known." Hamilton Holt proclaimed that the address cannot fail to rank in political importance with the Declaration of Independence. In an editorial entitled Mr. Wilson's Great Utterance, the New Republic suggested that the president might have engineered a decisive turning point in the history of the modern world. Not only has history failed to rank President Wilson's remarks with the historic pronouncements with which they were compared, at the time, his own Secretary of State, Robert Lansing, was deeply troubled by the concept of the self-determination of peoples. He wrote in his diary, "These phrases will certainly come home to roost and cause much vexation. The president is a phrase-maker par excellence. He admires trite sayings and revels in formulating them, but when he comes to their practical application he is so vague that their worth may well be doubted. He apparently never thought out in advance where they would lead or how they would be interpreted by others. In fact, he does not seem to care so that his words sound well. The gift of clever phrasing may be a curse unless the phrases are put to the test of sound, practical application before being uttered." 10 days later, Secretary Lansing returned to this subject in his diary. "The phrase is simply loaded with dynamite. It will raise hopes which can never be realized. It will, I fear, cost thousands of lives. In the end, it is bound to be discredited, to be called the dream of an idealist who failed to realize the danger until too late to check those who attempt to put the principle into force. What a calamity that the phrase was ever uttered! What misery it will cause! Think of the feelings of the author when he counts the dead who died because he coined a phrase." It should be noted that Lansing did not simply reach a different conclusion from that of Wilson's admirers. He applied an entirely different criterion, concrete results, rather than resonance with a vision. The military, economic, and social viability of the nations created by fiat after the First World War was not a question that the victors had sufficient time to address, much less answer. As in so many other contexts in which the people are invoked, the people themselves actually had little to say about the decisions involved. The so-called self-determination of peoples was in fact the determination of people's fate by foreigners, arrogating the role of surrogate decision-makers while having neither the degree of knowledge nor the accountability for consequences that might have made their decisions even plausible. Although the concept of the self-determination of peoples has been identified with Woodrow Wilson, the idea of a sweeping redrawing of national boundaries was already in the air. H.G. Wells, as early as 1914, had written of a need for a remapped and pacified Europe after the war, and said, "We are fighting now for a new map of Europe." In other words, his was the vision of the anointed shaping other people's lives, including the lives of whole foreign nations, the vision later expressed and carried out by Woodrow Wilson. Writing in 1915, Walter Lippmann, who would 4 years later become a member of President Wilson's delegation in Paris, saw the gross lack of knowledge of the peoples who were being proposed to be dealt with as if they were chess pieces being arranged to carry out some grand design. "We are feeding on maps, talking of populations as if they were abstract lumps, and turning our minds to a scale unheard of in history. When you consider what a mystery the east side of New York is to the west side, the business of arranging the world to the satisfaction of the people in it may be seen in something like its true proportions." The very idea of having each people have their own homeland ignored both history and demography, not to mention economics and military security. Locations of peoples and of national boundaries had already changed repeatedly and drastically throughout history. Much of the land in the world, and most of the land in the dismembered Habsburg and Ottoman empires, belonged to different sovereignties at different periods of history. The number of cities in those empires with multiple names from different languages over the centuries should have been a tip-off, quite aside from the mosques converted to churches and the churches converted to mosques. The idea of rescuing oppressed minorities ignored the prospect, since become a reality, that oppressed minorities who became rulers of their own nations would immediately begin oppressing other minorities under their control. The solution sought by Wilson and applauded by other intellectuals was as illusory as it was dangerous. Small and vulnerable states created by the dismemberment of the Habsburg Empire were later picked off, one by Hitler in the 1930s, an operation that would have been much more difficult and hazardous if he had to confront a united Habsburg Empire instead. The harm done extended beyond the small states themselves. A larger state, like France, was more vulnerable after Hitler took control of the military and other resources of Czechoslovakia and Austria. Today, NATO is in effect an attempt to consolidate individually vulnerable states, now that the empires of which some had been part are gone. As for Wilson's other famous sweeping phrase, "The world must be made safe for democracy," the actual concrete results of his policies led in the directly opposite direction, to brutal totalitarian regimes replacing the autocratic governments in Russia, Italy, and Germany. Despite the heartening news of the fall of the Tsarist government in Russia, to which Wilson referred in his speech asking Congress to declare war on Germany, the Kerensky regime that followed was then undermined by the Wilson administration itself, which made the granting of desperately needed loans to Russia contingent on Russia's continuing to fight a losing, disastrous, and bitterly unpopular war, leading within a year to the Bolshevik Revolution, inaugurating one of the bloodiest totalitarian regimes of the 20th century. In short, the end of autocracy, which Wilson and the intelligentsia in general so much welcomed, was followed not by the democratic governments which were expected to replace them, but by regimes worse than those they replaced. The Tsars, for example, did not execute as many political prisoners in 92 years as the Soviets executed in a single year. As in other contexts, intellectuals tended to act as if incessant criticisms and all-out opposition to the shortcomings of existing governments will lead to change, implicitly assumed to be a change for the better, no matter how often it has led to changes for the worse. Wilson was thus a quintessential intellectual in this as well. In later years, other autocratic governments denounced by later intellectuals, whether in China, Iran, or Cuba, were followed by totalitarian regimes more brutal and repressive internally and more dangerous on the world stage. The effects of Woodrow Wilson's administration on democracy within the United States were likewise negative, despite the rhetoric of making the world safe for democracy. Wartime restrictions on civilian liberties were much more widespread during America's relatively brief involvement in the First World War, all of it fought overseas, than during the much longer involvement of the United States in the Second World War, where the war was brought much closer to home, with Japanese attacks on Pearl Harbor and the Aleutian Islands, and German submarine attacks on American ships off the East Coast. Some of the landmark Supreme Court decisions on freedom of speech grew out of the Wilson administration's attempts to silence criticisms of its conduct of the war. During the relatively brief period of American military involvement in the First World War, little more than a year and a half, a remarkably large set of pervasive federal controls over the internal life of the United States were put into operation, confirming the progressive intellectuals' view of war as a golden opportunity for replacing traditional American individual economic and social decision-making processes with collectivist control and indoctrination. Quickly created boards, commissions, and committees were directed by the War Industries Board, which governed much of the economy, creating rationing and fixing prices. Meanwhile, the Committee on Public Information, aptly described as the West's first modern ministry for propaganda, was created and run by progressive George Creel, who took it as his mission to turn public opinion into one white-hot mass of support for the war, in the name of 100% Americanism, with anyone who refuses to back the president in this crisis being branded worse than a traitor. While the public was being propagandized on a mass scale by tens of millions of pamphlets and with war studies created in high schools and colleges, for example, a Sedition Act was passed, which forbade uttering, printing, writing, or publishing any disloyal, profane, scurrilous, or abusive language about the United States government or the military. Even the pro-war New Republic was warned that it could be banned from the mails if it continued to publish advertisements by the National Civil Liberties Bureau. All of this was promoted by the progressives, not inconsistently, but very consistently with their dirigiste vision, the vision of the anointed taking control of the masses in the name of collective goals to supersede the individual decisions that progressives saw as chaotic. The ultimate irony was that all this economic, political, and social repression was justified as part of the war in which the world must be made safe for democracy, a goal which itself was far removed from the ostensible cause of American military involvement, German submarine warfare. Just as the international repercussions of American involvement in the First World War did not end when the war ended, so the repercussions of the domestic policies of the Wilson administration did not end when the war ended. The widespread government control of the economy demonstrated, to John Dewey for example, the practicable possibilities of governmental regulation of private business, and that public control was shown to be almost ridiculously easy. As elsewhere, government orders were verbally transformed into the more politically acceptable euphemism, public control, and the ease of imposing such orders was equated with success at achieving their proclaimed goals. Moreover, the Wilson administration did not last long enough after wartime controls were instituted to determine their long-run effects in peacetime. As for the public, as distinguished from those who invoked its name in euphemisms, the public repudiated Wilson's progressivism at the polls and elected conservative administrations throughout the ensuing decade of the 1920s. But the heady experience of government intervention and control of the economy in wartime shaped the thinking of individuals who would later be supporters or participants in the New Deal administration of the 1930s, headed by Wilson's Assistant Secretary of the Navy, Franklin D. Roosevelt. The Second World War. Intellectuals between the World Wars. While the First World War reinforced the dirigiste tendencies of both the intelligentsia and of many in the political arena, it devastated the notions of those intellectuals who saw war as a beneficial social tonic domestically, or as a good means to spread progressive policies internationally. Despite those intellectuals who had rallied to the military interventionist policies of Woodrow Wilson in Latin America and in Europe, the unprecedented horrors and devastations of the First World War turned virtually the whole intellectual community of the Western world in the opposite direction, toward pacifism. Indeed, pacifism became a widespread attitude among much of the population at large, and therefore a potent political force in democratic nations. No matter how drastically intellectuals had been forced to change their minds in the wake of the First World War, they remained as convinced as ever that their views on the subject of war and peace were vastly superior to the views of the general public. Part of the reason for the spread of pacifism were circumstances, especially the grim and heart-rending experiences of the First World War, and part was due to how people reacted to circumstances, especially the intelligentsia, most severely the intelligentsia in France, which suffered most among the Western democracies. The most fundamental of these circumstances were the stark facts of that war itself. About 1,400,000 French lost their lives. Well over 1 million had been gassed, disfigured, mangled, amputated, left permanent invalids. Wheelchairs, crutches, empty sleeves dangling loosely or tucked into pockets became common sights. More than that had suffered some sort of wound. Half of the 6,500,000 who survived the war had sustained injuries. Most visible, 1,100,000 were those who had been evidently diminished and were described as mutilés, a term the dictionary translates as maimed or mangled, and English usage prefers to clothe in a euphemism, disabled. With most of the war on the Western Front fought on its own territory, France suffered tremendous casualties in the First World War. More than 1/4 of all Frenchmen between the ages of 18 and 27 were killed in the First World War. Moreover, neither the financial nor the human costs of the First World War ended when the war itself ended. Although the numbers of males and females in France's population were roughly equal before the war, the massive wartime casualties among young Frenchmen meant that in the 1930s the number of women between the ages of 20 and 40 exceeded the number of men of those ages by more than 1 million, meaning that more than 1 million women in the prime of life could not fulfill traditional expectations of becoming wives and mothers. During the 1930s, there were not enough babies born in France to replace the people who died during that decade. The sense of faith in the French government was also devastated, as people who had patriotically invested in bonds to help finance the First World War saw the value of those bonds drastically reduced by inflation, cheating some citizens out of their life savings. No country was more fertile soil for pacifism and demoralization, and no one created more of both than France's intelligentsia. Anti-war novels and the memoirs of military veterans found a vast market in France. A translation of the anti-war classic All Quiet on the Western Front sold 72,000 copies in 10 days and nearly 450,000 copies by Christmas. L'Humanité serialized it, and Vie Intellectuelle praised it. In 1938, the year of the Munich appeasement of Hitler, Echo de la Nièvre said, "Anything rather than war." Novelist Jean Giono, long critical of his own French government, likewise urged acceptance of Hitler's terms at Munich. Very similar trends were apparent in Britain in the years between the two world wars. In the late 1920s and early 1930s, the pacifist mood was being fueled by the flow of memoirs and novels exploring the horrors of the Great War. Richard Aldington's Death of a Hero and Siegfried Sassoon's Memoirs of a Fox-Hunting Man were published in 1928, and Robert Graves's Goodbye to All That, Ernest Hemingway's Farewell to Arms, and Eric Maria Remarque's All Quiet on the Western Front appeared in 1929. Louis Milestone's film of Remarque's book had a powerful impact. In addition to many anti-war novels about the First World War, 80 or more novels about the horrors of future wars were published in Britain between the First and Second World Wars. One of the remarkable developments of the 1920s was an international movement among intellectuals promoting the idea that nations should get together and publicly renounce war. As prominent British intellectual Harold Laski put it, "The experience of what world conflict has involved seems to have convinced the best of this generation that the effective outlawry of war is the only reasonable alternative to suicide." In the United States, John Dewey spoke of those who were skeptical of this movement for the international renunciation of war that he supported, which led to the Kellogg-Briand Pact of 1928, as people with the stupidity of habit-bound minds. He saw arguments against the renunciation of war as coming from those who believe in the war system. With Laski, Dewey, and others, the issue was not simply a matter of one hypothesis about war and peace versus another, but was a question of the anointed versus the benighted, the latter being dismissed with contempt, rather than having their arguments answered. Being a pacifist in the 1920s and 1930s was a badge of honor, and pacifist phrases facilitated admission to the circles of the self-congratulatory elites. At a 1935 rally of the British Labour Party, economist Roy Herod heard a candidate proclaim that Britain ought to disarm as an example to the others, a very common argument at that time. His response and the answer it provoked captured the spirit of the times. "You think our example will cause Hitler and Mussolini to disarm?" I asked. "Oh, Roy," she said, "have you lost all your idealism?" Others likewise presented pacifism in personal rather than policy terms. Author J. M. Murray, for example, said, "What matters is that men and women should bear their witness." However, pacifist Marjorie South objected to pacifism becoming a precious doctrine which has as its objective the regeneration of the individual rather than the prevention of war. Here, as in other cases, the vision of the anointed was a vision about themselves, not just about the ostensible issue at hand. Like Marjorie Smith, John Maynard Keynes also objected to having national policies be based on the urge to save one's own soul. Given the high personal psychic stakes for pacifists, it is not surprising that those with a contrary opinion on issues of war and peace, as on other issues, were lashed out at, as personal enemies, or as people threatening their soul, and were demonized rather than answered. As noted in Chapter 4, Bertrand Russell claimed that the man who opposed pacifism was someone who delights in war and would hate a world from which it had been eliminated. In a very similar vein, H.G. Wells spoke of a substantial portion of human beings who definitely like war, know they like war, want it, and seek it. Kingsley Martin, longtime editor of the influential New Statesman, likewise characterized Winston Churchill in 1931 as someone whose mind is confined in a militaristic mold, as a psychological explanation of Churchill's advocacy of keeping the French army and the British Navy at full strength. More generally, Kingsley Martin treated those with views different from his own regarding war and peace as having psychological defects, rather than having arguments that required being answered with other arguments. To have a foreign enemy in the offing enables us to hate with a good conscience. It is only in time of war that we get a complete moral holiday, when all the things which we have learned at our mother's knee, all the moral inhibitions imposed by education and society, can be wholeheartedly thrown aside when it becomes justifiable to hit below the belt, when it is one's duty to lie, and killing is no longer murder. In short, the unworthiness of opponents was taken as axiomatic, making substantive arguments against their arguments unnecessary. Kingsley Martin was not alone. Churchill's colleagues in Parliament were equally dismissive. Such views were not peculiar to British and American intellectuals. The French intelligentsia played a major role in the promotion of pacifism between the two world wars. Even before the Treaty of Versailles was signed, internationally renowned French writer Romain Rolland, recipient of France's Grand Prix de Littérature, later elected to the Russian Academy of Sciences and offered the Goethe Prize by Germany, and recipient of the Nobel Prize for Literature, issued a manifesto calling on intellectuals in all countries to oppose militarism and nationalism in order to promote peace. In 1926, prominent intellectuals from a number of countries signed an internationally publicized petition calling for some definite step toward complete disarmament and the demilitarizing of the mind of civilized nations. Among those who signed were H.G. Wells and Bertrand Russell in England, and Romain Rolland and Georges Duhamel in France. The petition called for a ban on military conscription, in part to rid the world of the spirit of militarism. Behind such arguments was the crucial assumption that both physical and moral disarmament were necessary to sustain peace. Neither in this petition nor in other statements expressing similar views was there much, if any, expressed concern that both kinds of disarmament would leave the disarmed nations at the mercy of those nations which did not disarm in either sense, thus making a new war look more attractive to the latter because it would look more winnable. Hitler, for example, banned the anti-war classic All Quiet on the Western Front, as he wanted neither moral nor physical disarmament in Germany, but carefully followed both phenomena in Western democracies as he plotted his moves against them. Pacifists of this era seemed not to think of other nations as prospective enemies, but of war itself as the enemy, with weapons of war and those who manufactured these weapons, merchants of death being the fashionable phrase of the times and the title of a best-selling 1934 book, also being enemies. The merchants of death wax fat and bloated, declared John Dewey in 1935. Romain Rolland called them profiteers of massacre. H.G. Wells said, "War equipment has followed blindly upon industrial advance until it has become a monstrous and immediate danger to the community." Harold Laski spoke of the wickedness of armaments. Aldous Huxley referred to a battleship as a repulsive insect, a huge bug which squatted there on the water, all its poisonous armory enlarged into instruments of destruction, every bristle a gun, every pore a torpedo tube, and added, "Men had created this enormous working model of a loathsome insect for the express purpose of destroying other men." Pacifists did not see military forces as deterrents to other nations' military forces, but as malign influences in and of themselves. J.B. Priestley, for example, said, "We should distrust any increase in armaments," one reason being that heavy competitive arming produces fear. Moreover, once a nation is heavily armed, it has to keep playing at war, and from playing at war to the actual waging of war is a very short step. Famed author E.M. Forster, A Passage to India, said that he was shocked to realize that his stock in Imperial Chemical was stock in a company that potentially could produce war weapons, even though currently, 1934, it was not an armament firm, and he promptly sold all his shares of that stock. A year later he said, "One of my reasons for voting Labour last week was that I hoped it would arm us inadequately, would, in more decorous language, keep us out of the armament race when disaster seems assured." Such views, seeing weapons rather than other nations as the danger, were not simply intellectual fashions, but created political bases for national policies and international agreements, beginning with the Washington Naval Agreements of 1921 and 1922 among the leading naval powers of the world to limit the number and size of warships, agreements hailed by John Dewey, among others, and the Kellogg-Briand Pact of 1928, renouncing war. "Away with rifles, machine guns, and cannon," said France's Foreign Minister Aristide Briand, co-author of the Kellogg-Briand Pact. In a letter to the New Republic in 1932, Romain Rolland urged, "Unite, all of you, against the common enemy. Down with war." Later, Georges Duhamel, looking back on the interwar pacifists in France, including himself, summarized their approach, which avoided seeing other nations as potential enemies. For more than 12 years, Frenchmen of my kind, and there were many of them, spared no pains to forget what they knew about Germany. Doubtless it was imprudent, but it sprang from a sincere desire on our part for harmony and collaboration. We were willing to forget. And what were we willing to forget? Some very horrible things. The view of war itself, rather than other nations, as the enemy, began shortly after the end of the First World War, as did the idea that patriotism must be superseded by internationalism in the interests of peace. Addressing school teachers in 1919, Anatole France urged that they use the schools to promote pacifism and internationalism. "In developing the child, you will determine the future," he said. "The teacher must make the child love peace and its works. He must teach him to detest war. He will banish from education all that which excites hate for the stranger, even hatred of the enemy of yesterday," he added. Anatole France declared, "We must be citizens of the world or see all civilization perish." Such ideas became dominant in French schools during the next 2 decades. A key role in the spread of pacifism in France was played by the schools, more specifically by the French teachers' unions, which began organized campaigns in the 1920s, objecting to post-war textbooks favorably depicting the French soldiers who had defended their country against German invaders in the First World War. Such textbooks were called bellicose, a verbal tactic still common among those with the vision of the anointed, of reducing views different from their own to mere emotions, as if in this case only pugnaciousness could account for resisting invaders, or for praising those who had put their lives on the line to do so. The leading teachers' union, the Syndicat National des Instituteurs, SN, launched a campaign against those textbooks of bellicose inspiration, which it characterized as a danger for the organization of peace. Since nationalism was said to be one of the causes of war, internationalism, or impartiality among nations, was considered to be a required feature of textbooks. This was not thought of as being against patriotism, but, at the very least, it lessened the sense of obligation to those who had died to protect the nation, with its implicit obligation on members of generations that followed to do the same, if and when that became necessary again. Leaders of the drive to rewrite history textbooks called their goal moral disarmament, to match the military disarmament which many regarded as another key to peace. Lists of textbooks targeted for removal from the schools were made by Georges Lapierre, one of the SN leaders. By 1929, he was able to boast of all the bellicose books the SN campaign had gotten taken out of the schools, rewritten, or replaced. Faced with the threat of losing a share of the large textbook market, French publishers caved in to union demands that books about the First World War be revised to reflect impartiality among nations and to promote pacifism. The once epic story of French soldiers' heroic defense at Verdun, despite the massive casualties they suffered, was now transformed into a story of horrible suffering by all soldiers at Verdun, from bullets, shells, poison gas, frostbite, presented in the much sought-after spirit of impartiality. Imagine the life of these combatants, French, allies, or enemies. In short, men who had once been honored as patriotic heroes for having sacrificed their lives in a desperate struggle to hold off the invaders of their country were now verbally reduced to victims and put on the same plane as other victims among the invaders. Ceremonies dedicating monuments to commemorate soldiers who had died in battle were sometimes turned into occasions for speeches promoting the pacifist ideology. Among those who tried to warn against moral disarmament was Marshal Philippe Pétain, the victor of the Battle of Verdun, who in 1934 said that French teachers were out to raise our sons in ignorance of or in contempt of the fatherland. Years later, during the Second World War, one of the alerts issued to French soldiers said, "Remember the Marne and Verdun." But this was said to a generation that had been taught to see the Marne and Verdun not as historic sites of patriotic heroism by French soldiers, but as places where soldiers on all sides had been victims alike. France's behavior in the Second World War was in extraordinary contrast with its behavior in the First World War. France fought off the German invaders for 4 long years during the First World War, despite suffering horrendous casualties, more wartime deaths than a larger country like the United States has ever suffered in any war, or in all its wars put together. Yet during the Second World War, France surrendered after just 6 weeks of fighting in 1940. In the bitter moment of defeat, the head of the teachers' union was told, "You are partially responsible for the defeat." Charles de Gaulle, François Mauriac, and many other Frenchmen blamed a lack of national will or general moral decay for the sudden and humiliating collapse of France in 1940. Although France's sudden collapse caught much of the world by surprise, Winston Churchill had said as far back as 1932, France, though armed to the teeth, is pacifist to the core. Hitler was not surprised by France's sudden collapse, and had in fact predicted it. When he pressed his generals to draw up plans for the invasion of France immediately after the swift German victory in Poland in the autumn of 1939, the generals' analyses of the various military and logistical factors involved led them to doubt that such a project could be undertaken, with any realistic hope of success, before 1941, or perhaps even 1942. But the most delay that Hitler would grant them was until the spring of 1940, which in fact was when the German invasion of France began. Hitler's reasons were wholly different from the objective factors which German generals had analyzed. It was based on his analysis of the French themselves. Hitler said that France was no longer the same as the France that had fought doggedly through 4 years of the First World War, that the contemporary French were lacking in the personal strengths necessary for victory, and would falter and surrender. That is, in fact, largely what happened. The objective factors, such as the number and quality of military equipment available to France and its British allies versus those available to the German invaders, led military leaders in both France and Germany at the time to conclude at the outset that France had the greater prospects of victory. But Hitler had long made a study of public opinion, as well as official opinion, in France and Britain. The words and deeds of both politicians and pacifists in those countries went into Hitler's calculations. The invasion of France took place when it did only because Hitler adamantly insisted upon it, dismissing the advice of his own top generals. Decades later, scholarly studies in both France and Germany reached the same conclusion as that of French and German military leaders in 1940, that the objective military factors favored a French victory, and certainly nothing like the swift and total collapse that occurred. How much of that collapse can be attributed to the large role of chance and misjudgments inherent in war, and how much to a fundamental inner erosion of morale, patriotism, and resolution among the French themselves, is a question unlikely to be answered definitively. What is clear, however, is that the irresolution which marked French political responses to the German threat in the years leading up to the Second World War carried over into the war itself, beginning with the long months of the Phony War from September 1939 to May 1940, during which France had overwhelming military superiority on Germany's Western Front, while German military forces were concentrated in the east, fighting Poland, and yet France did nothing. The German general responsible for defending the vulnerable Western Front said, "Every day of calm in the West is for me a gift from God." In the earliest days of the war, when German military forces were most heavily concentrated on the Eastern Front, one of the generals under his command had informed him that if the French attacked, he did not have enough resources to stop them for even one day. Even a civilian like American foreign correspondent William L. Shirer was amazed as he observed the French in action during the Phony War and their irresolution and ineptness when the Germans attacked in 1940. While France was the most dramatic example of moral disarmament during the interwar years, it was by no means the only country in which such views prevailed among the intelligentsia. British pacifists likewise often depicted wars as being a result of national emotions or attitudes, rather than calculations of self-interest by aggressive rulers. In a 1931 editorial in the New Statesman and Nation, Kingsley Martin said that modern war is the product of ignorance and idealism, not of far-sighted wickedness. Therefore, what was needed to prevent a future war was bringing up a new generation to recognize that martial patriotism is an out-of-date virtue, because taking part in a future war would be something that is individually shameful as well as socially suicidal. Bertrand Russell defined patriotism as a willingness to kill and be killed for trivial reasons. In 1932, British author Beverly Nichols publicly declared himself in favor of peace at any price, and later wrote Cry Havoc, one of the most prominent pacifist books of the decade. In 1933, students at Oxford University publicly pledged themselves not to fight in defense of their country, and what became known as the Oxford Pledge spread rapidly to other British universities, as well as being echoed in Britain by such intellectuals as Cyril Joad and A. A. Milne, famous author of Winnie the Pooh, and in France by André Gide, who spoke of the courageous students of Oxford. Joad said that the best way to ensure peace is to refuse in any circumstances to make war. He urged an intensive campaign to induce the maximum number of young people to announce their refusal to fight in any war between nations. Joad was one of those who wrote graphically of the horrors and agonies of war, though Winston Churchill warned that Britain cannot avoid war by dilating upon its horrors. In Britain, as in France, patriotism was considered suspect as a cause of war. H.G. Wells, for example, declared himself against the teaching of patriotic histories that sustain and carry on the poisonous war-making tradition of the past, and wanted British citizenship replaced by world citizenship. He regarded patriotism as a useless relic to be replaced by the idea of cosmopolitan duty. J.B. Priestley likewise saw patriotism as a mighty force chiefly used for evil. A letter to the Times of London in 1936, signed by such prominent intellectuals as Aldous Huxley, Rebecca West, and Leonard Woolf, called for the spread of the cosmopolitan spirit and called for writers in all countries to help all peoples to feel their underlying kinship. Meanwhile, Hitler was following such developments in Britain and France as he made his own plans and assessed the prospects of military victory. Almost as remarkable as the lengths to which the pacifists of the 1930s went was the verbal virtuosity with which they downplayed the dangers of the pacifism they were advocating, while Hitler was rearming on a massive scale in Germany and promoting the very patriotism among Germans that was being eroded by the intelligentsia in the democracies. Bertrand Russell used an argument that went as far back as 1793, when William Godwin claimed that a country which presented no military threat or provocation to other nations would not be attacked. If Britain would reduce its armed forces, as Bertrand Russell advocated, we should threaten no one, and no one would have any motive to make war on us. Russell explained further, when disarmament is suggested, it is natural to imagine that foreign conquest would inevitably follow, and would be accompanied by all the horrors that characterize warlike invasions. This is a mistake, as the example of Denmark shows. Probably, if we had neither armaments nor empire, foreign states would let us alone. If they did not, we should have to yield without fighting, and we should therefore not arouse their ferocity. According to Russell, if you declare that you are prepared to be defenseless and trust to luck, the other people, having no longer any reason to fear you, will cease to hate you, and will lose all incentive to attack you. The reason for this conclusion was Lord Russell's claim, in most civilized men, resistance is necessary to arouse ferocity. From this it followed that fear of an impending war should lead to unilateral disarmament. Such reasoning was not peculiar to Bertrand Russell nor unique to Britain. In France, a book by the head of the French Socialist Party, and later Premier, Léon Blum, said, "If a nation thus undertook to disarm, it would not in reality incur any risk, because the moral prestige which it would acquire would render it invulnerable to attack, and the force of its example would induce all other states to follow." Another element in the pacifist case of the 1930s, in both France and Britain, was that even a victory in war would make no real difference. According to Bertrand Russell, victory will be no less disastrous to the world than defeat would have been. Because of the need for tight wartime control of a panicked population, anarchy will only be prevented by a military dictatorship, which may not prove to be temporary, so that the end result of even a victorious war will be the substitution of an English Hitler for the German one. Kingsley Martin likewise saw a new war as one from which no one can emerge victorious, that war would totally end civilization. In France, novelist Jean Genot asked what was the worst that could happen if the Germans invaded France. The French would become Germans, he said. I prefer being a living German to being a dead Frenchman. Literary figure Simone Weil argued along similar lines, asking, why is the possibility of a German hegemony worse than French hegemony? Just a little over 2 years after this abstract question about abstract countries, the Nazi conquest of France made the consequences of Hitler's hegemony much more painfully specific. In the aftermath of France's defeat, Simone Weil, being of Jewish ancestry, though a practicing Christian, fled the dangers of genocidal Nazi rule in France and died in England during the war. Georges Lapierre, who had spearheaded the drive against bellicose textbooks in French schools, became, in the wake of France's defeat, part of the underground resistance to Nazi rule, but was captured and sent to the Dachau concentration camp, where he died. Weil and Lapierre learned from experience, but too late to spare themselves or their country the consequences of the things they had advocated. Meanwhile, Jean Genot collaborated with the Nazi conquerors, nor was he alone in this among French intellectuals. Widespread pacifist sentiments among the intelligentsia in Britain during the interwar period were echoed in the political arena by leaders of the British Labour Party. In June 1933, at the East Fulham by-election, the Labour candidate received a message from the Labour Party leader, George Lansbury. I would close every recruiting station, disband the army, and disarm the Air Force. I would abolish the whole dreadful equipment of war, and say to the world, do your worst. Clement Attlee, who was to succeed him as leader, told the Commons, 21 December 1933, "We are unalterably opposed to anything in the nature of rearmament." Labor consistently voted, spoke, and campaigned against rearmament right up to the outbreak of war. 2 years later, Attlee said, "Our policy is not of seeking security through rearmament, but through disarmament." As late as 1937, Harold Laski said, "Are we really to support this reactionary government in rearming for purposes it refuses specifically to declare?" The Labour Party's opposition to military preparedness did not change until the working-class component of the Labour Party, represented by its unions, eventually overcame its intellectual component, represented by Laski and others, with a doctrinaire opposition to military defense. A 1938 editorial in the New Statesman and Nation deplored the labor unions supporting rearmament without getting some quid pro quo in the form of influence over the government's international policies or forcing the government to limit effectively the profits of the arms industry. In short, to intellectual supporters of the Labour Party, rearmament was still an ideological issue a year before the Second World War began, rather than a matter of national survival. Similar anti-military and anti-armament views were common among the American intelligentsia. John Dewey, Upton Sinclair, and Jane Addams were among the American signers of a 1930 manifesto against military training for youths. In 1934, Oswald Garrison Villar urged a decrease by 1/3 of the United States Army and the mustering out of 50% of our reserve officers as evidence of our good faith. Nor were such sentiments among intellectuals without influence upon holders of political power. When the Roosevelt administration cut the Army's budget, Army Chief of Staff General Douglas MacArthur had an angry confrontation with the President, offered his resignation, and was still so upset as he left the White House that he vomited on the steps. In such an atmosphere between the two world wars, international disarmament conferences and agreements in which nations renounced war became very popular in the Western democracies. But as with domestic gun control laws, the real question is whether arms limitation treaties actually limit the arms of anyone except those who respect the law, whether international or domestic. Both Japan and Germany violated armaments limitations agreements that they had signed, producing, among other things, larger battleships than these treaties allowed, and larger than anything in either the British or American navies. Violations of arms control treaties are not a happenstance. Such agreements are inherently one-sided. Leaders of democratic nations are under more pressure to sign such agreements than are leaders of dictatorships that can control, suppress, or ignore public opinion. In democratic nations, neither academic nor media intellectuals are usually as concerned with scrutinizing the specifics of disarmament agreements as they are with celebrating the symbolism of the signing of such agreements and the easing of international tensions that they bring, as if emotional catharsis will deflect governments bent on military aggression. Thus, intellectuals like John Dewey had cheered on the Washington Naval Agreements of 1921-1922, and the Times of London praised the Anglo-German Naval Agreement of 1935 as the outstanding fact in Anglo-German relations, as an emphatic renunciation of hostile purpose towards this country by Germany, and a clear-sighted decision of Herr Hitler himself. Conversely, those with this vision roundly condemn leaders of their own country who refuse to compromise in order to reach such agreements. In addition to terms that explicitly tend to favor those nations whose intelligentsia are not free to criticize their governments, subsequent violations of these agreements by aggressor nations are more likely to be tolerated by leaders of democratic nations who have no incentive to be quick to announce to their own citizens that they have been had in signing agreements that were widely publicized and widely celebrated when they were signed. The intelligentsia do not need to convert political leaders to their own pacifist views in order to affect government policy. Leaders of democratic nations must always face the prospect of elections, and the atmosphere in which those elections are held is a fact of life to politicians seeking to keep their careers alive and their party in power. Thus, although clandestine German rearmament in violation of treaties began even before Hitler came to power in 1933, this was secret only in the sense that the German government did not acknowledge it, and the general public in Western democratic countries were not made aware of it. But it was not secret from democratic leaders who received intelligence reports. British Conservative Party leader and later Prime Minister Stanley Baldwin, for example, was well aware of what was going on, but was also well aware of the political repercussions if he publicly announced German rearmament. In response to a speech in the House of Commons in 1936 by Winston Churchill, then a backbencher, charging that the British government had engaged in one-sided disarmament and that the British Army lacks almost every weapon which is required for the latest form of modern war, Prime Minister Baldwin replied in terms of what the political realities were at the time of the 1933 elections. Supposing I had gone to the country and said that Germany was rearming and that we must rearm, does anybody think that this pacific democracy would have rallied to that cry at that moment? I cannot think of anything that would have made the loss of the election from my point of view more certain. Even a dozen years later, writing his monumental post-war 6-volume history, The Second World War, Churchill remained repelled by Baldwin's answer. This was indeed appalling frankness. It carried naked truth about his motives into indecency. That a prime minister should avow that he had not done his duty in regard to national safety because he was afraid of losing the election was an incident without parallel in our parliamentary history. Mr. Baldwin was, of course, not moved by any ignoble wish to remain in office. He was, in fact, in 1936, earnestly desirous of retiring. His policy was dictated by the fear that if the Socialists came into power, even less would be done than his government intended. All their declarations and votes against defense measures are upon record. Here, as in many other situations, the intelligentsia's effect on the course of events did not depend upon their convincing the holders of power. All they had to do was convince enough of the public so that the holders of power became fearful of losing that power if they went against the prevailing vision, pacifism in this case. If Baldwin had lost power, he would have lost it to those who would turn the pacifist vision into a reality potentially disastrous to the country. Britain, after all, narrowly escaped being invaded and conquered in 1940, and only because of a belated development of its interceptor fighter planes that shot down German bombers during the aerial blitz that was intended to prepare the way for the invasion force being mobilized across the English Channel. Had the pacifists in the Labour Party come to power in 1933, it is by no means clear that this narrow margin of survival would have been in place. There was a similar reluctance among leaders in France to alert the public to danger, or perhaps even to acknowledge the dangers to themselves. Although French Foreign Minister Aristide Briand was well aware of the dramatically rising political support for the Nazis in the 1930 German elections, and what that portended in terms of a military threat to France, like Baldwin, he was not prepared to alarm the public. Briand was untroubled. Hitler will not go far, he assured the press, while doing his best to keep news of German militarism reviving from the French public. Parades and demonstrations of the German right were completely suppressed in newsreels shown in French movie houses, reported the American military attaché. Even before Hitler came to power, French intelligence agents had already penetrated Germany's clandestine military build-up. But neither the press nor the politicians wanted to tell the French public things that they did not want to hear, after all the traumas that they had been through during the First World War. Even after a further escalation of the vote for the Nazis in the 1932 elections brought Hitler into the German government, evasion or denial of the dangers to France continued. In the new German elections, the Nazis became the largest party in the Reichstag, but the French press was not impressed. President Hindenburg had brought in General von Schleicher to hold the fort against the house painter demagogue. Newspapers from left to right celebrated the piteous end of Hitlerism, Louvre, January 1, 1933, and the decadence of Hitler's movement, Paris Soir, January 1, 1933. The German Boulanger had missed the boat, exulted L'Echo de Paris, November 7, 1932, forgetting how law-abiding the populist 19th-century general had been. The Socialist Populaire and the Royalist Action Française agreed. Hitler was henceforth excluded from power. But Schleicher resigned as January 1933 ended, and the demagogue found himself in power after all. A pacifist dedicated his latest book, Peace on Earth, to Adolf Hitler. As in other times and in other contexts, it is worth noting in passing the know-it-all tone of condescension in the press, which is a corollary of self-exaltation among the intelligentsia. However understandable the French desire to avoid a repetition of the horrors they had experienced in the First World War, their intellectuals' resolute denials of the dangers building up across the Rhine reached high levels of unreality. One of the early signs of this unreality was the celebration of the Kellogg-Briand Pact of 1928, outlawing war. Named for an American Secretary of State and the French Foreign Minister, this pact received virtually unanimous approval in the French press. Nothing is easier than to get peaceful people to renounce violence, even when they provide no concrete ways to prevent violence from others. The French did not want to hear anything bad about Germany. Even Hitler's Mein Kampf, which spelled out his hostile intentions toward France, did not get through to the intelligentsia or to the public because a French court stopped its full translation, so that only expurgated versions were available to the few who were interested. By the late 1930s, as refugees from Germany fled to France, bearing stories of the horrors of the Nazi regime, their stories were not only widely rejected, but because many of these refugees were Jewish, this provoked increased anti-Semitism, based on the notion that Jews were trying to provoke a war between France and Germany. Anti-Semitism was not confined to the masses, but was common among French intellectuals as well. In Britain, as in France, there was a strong resistance among the intelligentsia to recognizing the nature of the Nazi regime within Germany or the external threat that it posed to Western democracies. The influential Manchester Guardian said that, despite the Nazis' radical ideas, they would act like ordinary politicians when they took office. Britain's largest circulation newspaper at the time, the Daily Herald, dismissed Hitler as a clown and opined that he would share the fate of his immediate predecessors as Chancellor of Germany, whose terms had lasted only a matter of weeks. The Daily Telegraph likewise said that Hitler was done for and would be gone before the end of 1932. Harold Laski likewise declared in 1932 that the Hitlerite movement has passed its apogee, that Hitler was a cheap conspirator rather than an inspired revolutionary, the creature of circumstances rather than the maker of destiny. The most influential British newspaper, The Times of London, considered Hitler a moderate, at least compared to other members of his party. After Hitler and the Nazis achieved supreme power in Germany in 1933, The Times was especially resistant to letting news of the Nazis' domestic oppressions or international threats reach the public. Dispatches from the Times' own foreign correspondents in Germany were often filtered, rewritten, and sometimes rejected outright when they reported the raw reality of what was happening under Hitler. Complaints from these correspondents were unavailing, and some resigned in protest against the newspaper's filtering of their dispatches critical of the Nazi regime, and reassigning them to places away from crucial events in Germany, while the Times editorials supported Prime Minister Neville Chamberlain's appeasement policies toward Germany. Times editor Geoffrey Dawson wrote candidly to his Geneva correspondent, "I do my utmost, night after night, to keep out of the paper anything that might hurt their German susceptibilities. I have always been convinced that the peace of the world depends more than anything else upon our getting into reasonable relations with Germany." Here, as in other contexts, the harm done by the intelligentsia seems especially great when they step out beyond the bounds of their competence, in this case gathering and reporting news, to seek a wider and greater role in shaping events, in this case by filtering news to fit their vision. Responses to international crises. The ideas pervasive among the intelligentsia between the two world wars would be no more than a footnote to the history of the times if these ideas did not have repercussions on the society at large, and indeed on the history of the world. But the influence of the ideas spread by the intelligentsia became apparent in the series of international crises that led up to the Second World War. The first of these crises involved the Rhineland in 1936. After the shock of the First World War, the Treaty of Versailles sought to render Germany's huge military potential less dangerous through various restrictions, including limitations on the size of German military forces, a ban on military conscription in Germany, and forbidding the German government from stationing troops in the Rhineland, the region of Germany where its industrial capacity was concentrated. This last provision meant that any future German attacks on other nations risked having its own undefended industrial sector seized by the French. These otherwise objectionable limitations on national sovereignty were clearly based on not seeing Germany as an abstract nation in an abstract world, but as the most dangerous threat to the nations around it, both from the military prowess it had demonstrated in the First World War, inflicting casualties on its enemies at much higher than its own casualty rate, and from its industrial predominance in Europe and its central location on the continent, from which it could strike in any direction. With the passage of time, however, the British intelligentsia by the 1930s were discussing these restrictions on Germany as if Germany were an abstract nation in an abstract world. The fact that Germany was being treated unequally under the Versailles Treaty was seen by much of the British intelligentsia as a reason why it would be wrong to forbid the German government from doing things that other governments did. As Winston Churchill noted in his aptly titled book, The Gathering Storm, When, in 1932, the German delegation to the Disarmament Conference categorically demanded the removal of all restrictions upon their right to rearm, they found much support in the British press. He added, "The Times spoke of the timely redress of inequality, and the New Statesman of the unqualified recognition of the principle of the equality of states. This meant that the 70 million Germans ought to be allowed to rearm and prepare for war, without the victors in the late fearful struggle being entitled to make any objection. Equality of status between victors and vanquished, equality between a France of 39 millions and a Germany of nearly double that number." In short, the mundane specifics, on which matters of life and death depended, were subordinated by the intelligentsia to abstract principles about abstract nations. Germany was to be treated just as if it were Portugal or Denmark, even though the restrictions imposed by the Treaty of Versailles were due precisely to the fact that Germany had not behaved like Portugal or Denmark, and had a military capacity vastly greater than that of Portugal or Denmark. With the rise to power of Adolf Hitler in 1933, unrestricted German rearmament went from being a demand to becoming a reality, in stages, beginning cautiously and then continuing more boldly, as the Western democracies did nothing to enforce the restricting provisions of the Treaty of Versailles. Because of the initially small size of the German military under those restrictions, these violations began at a time when France alone had overwhelming military superiority over Germany and could have intervened unilaterally to stop the buildup of the Nazi military machine, a fact of which Hitler was vividly aware, and German military leaders even more fearfully so. The crucial step, without which the Nazis' wars of aggression would be impossible, was the stationing of German troops in the country's industrial region, the Rhineland. Only after its own industry was secured could Germany attack other nations. Hitler clearly understood both how essential the stationing of German troops in the Rhineland was, and how risky it was, given the relative sizes of the French and German armies at the time. The 48 hours after the march into the Rhineland, Paul Schmidt, his interpreter, heard him later say, were the most nerve-wracking in my life. If the French had then marched into the Rhineland, we would have had to withdraw with our tails between our legs, for the military resources at our disposal would have been wholly inadequate for even a moderate resistance. The stakes were the highest: military conquests abroad, or the collapse of the Nazi regime within Germany. A retreat on our part, Hitler later admitted, would have spelled collapse. Hitler bet everything on irresolution by the French. He won his bet, and tens of millions of people later lost their lives as a result. Yet this action in the Rhineland, like others before it, continued to be viewed among the British intelligentsia as an abstract question about abstract nations. A phrase repeated again and again in the British press after Hitler sent troops into the Rhineland was that, after all, they are only going into their own back garden. A very similar view was taken in the French press. Despite French military superiority, the lack of political will paralyzed them from using that military superiority to prevent Hitler from remilitarizing the Rhineland. Nowhere in France was there the slightest indication that the public wanted or would even tolerate military action on account of German remilitarization of the Rhineland. The satirical weekly, Le Canard Enchaîné, expressed a common view when it said, "The Germans have invaded Germany." Communist leaders, supposedly in the forefront of opposition to Nazism, called stridently for preventing the scourge of war from falling anew on us. They urged that the whole nation unite against those who want to lead us to massacre. Socialist spokesmen termed inadmissible any response that risked war, saying that even reinforcing the Maginot Line would be provocative. The right-wing dailies, Le Matin and Le Jour, declared that conflict with Germany would benefit only communist Russia. Nor were such views confined to France. When the French Foreign Minister, Pierre-Étienne Flandin, met with British Prime Minister Stanley Baldwin to ask for British political support for action that France might take in response to German remilitarization of the Rhineland, France already having the military means to respond unilaterally. According to Flandin, Baldwin's response was, "You may be right, but if there is even 1 chance in 100 that war would follow from your police operation, I have not the right to commit England." This kind of thinking was commonplace at the time, as if there were no dangers from inaction to be weighed in the balance. In retrospect, we now know that Western democracy's inaction in response to Hitler's repeated provocations were crucial to his decisions to move toward war, confident that Western leaders were too timid to respond in time, or perhaps even at all. This was especially clear in other international crises leading up to the Second World War. The West's half-hearted and ineffective response to Mussolini's invasion of Ethiopia in 1935, in defiance of the League of Nations, was one of the inactions which led Hitler to doubt their will. Their inaction in response to the German remilitarization of the Rhineland in 1936, and to both Germany's and Italy's interventions into the Spanish Civil War that same year, followed by the Western democracies' inaction in response to Germany's annexation of Austria in 1938, all contributed to his contempt for Western leaders and his confidence that they would do nothing more than talk. The crisis that most solidified that confidence on Hitler's part was the crisis over his demand to annex Czechoslovakia's Sudetenland, adjacent to Germany and populated mostly by people of German ancestry. At the Munich Conference in 1938, France, Britain, and Italy concurred in Hitler's annexation of the Sudetenland, abandoning Czechoslovakia to its fate, despite France's mutual defense treaty with Czechoslovakia. The power of the intelligentsia is demonstrated not only by their ability to create a general climate of opinion that strikes fear into those who oppose their agenda, but also by their ability to create a climate of opinion which richly rewards those political leaders whose decisions are consonant with the vision of the intelligentsia. There has probably never been a leader of a democratic nation more widely or more enthusiastically acclaimed by the public, in the press, and by members of opposition parties as well as his own, as British Prime Minister Neville Chamberlain was when he returned from the Munich Conference of 1938, waving an agreement with Hitler, which he characterized as producing peace for our time. Less than a year later, the biggest and most bloody war in all of human history began. Seeing each of Hitler's successive demands as a separate issue, the perspective of one-day-at-a-time rationalism, the French press saw the 1938 demand for German annexation of Czechoslovakia's Sudetenland as a question of, should the French get themselves killed for Benish, the Freemason, as Je suis partout put it, and in 1939, as Hitler demanded German annexation of Poland's lone port of Danzig, Gdansk, the question was posed as, do we have to die for Danzig, as a headline in Louvre put it. The phrase, why die for Danzig, was considered a hallmark of sophistication among the intelligentsia at the time, but was instead a sign of their dangerous talent for verbal virtuosity, which can pose questions in ways that make the desired answer almost inevitable, whatever the substantive merits or demerits of the issue. Contrary to one-day-at-a-time rationalism, the real question was not whether it was worth dying over the Rhineland, over Czechoslovakia, over Austrian annexation, or over the city of Danzig. The question was whether one recognized in the unfolding pattern of Hitler's actions a lethal threat. By 1939, the French public seemed to have reached a more realistic understanding of what Hitler was doing than some of the country's intelligentsia. A poll in France in 1939 showed 76% of the public willing to use force in defense of Danzig. A history of this period noted that French Premier Édouard Daladier complained that he could not appear in an open place or in a bistro without seeing people stand up and cry, "Lead, we will follow you." Still, this was very late in the day, just months before the outbreak of the Second World War. The pervasive pacifism of that era and its political consequences had left France backed into a corner, where it now faced the prospect of war after having lost potential allies whom it had thrown to the wolves, in the hope of being spared Hitler's wrath themselves. As noted in Chapter 2, among the military equipment used by the Germans when they invaded France in 1940 were tanks manufactured in Czechoslovakia. The outbreak of war. The aggressor Axis nations in the Second World War, Germany, Italy, and Japan, did not have the resources, and were well aware that they did not have the resources, to match the combined resources of the democratic nations, including Britain, France, and the United States, in an arms race. Achieving the goals of the Axis powers depended on 1. The Western democracies not mobilizing their resources in time to stave off devastating defeats, which in fact the Axis inflicted time and time again during the first 3 years of the Second World War, and 2. Not having the fortitude to continue fighting in the face of an unbroken string of bloody losses and retreats, both in Europe and in Asia, until such time as their greater resources could eventually be mobilized to begin counterattacks. That strategy came dangerously close to success. It was November 1942, 3 years after Britain had entered the Second World War, before British Prime Minister Winston Churchill could say, after the Battle of El Alamein in North Africa, "We have a new experience. We have victory." There had been nothing but a steady stream of defeats and retreats for the British up to that point, both in Europe and in Asia, and few expected Britain itself to survive in 1940, after France fell to defeat in just 6 weeks of fighting, and the Luftwaffe launched its massive bombings of London and other British cities. Americans also had their first military victory in 1942, with incredible good luck overcoming lopsided Japanese naval superiority at the Battle of Midway. Intellectuals played a major role in bringing both Britain and the United States to such a desperate situation, with a steady drumbeat of pacifist, anti-national defense efforts between the two world wars. In October 1938, a month after Munich and less than a year before the beginning of the Second World War, the influential British journal New Statesman and Nation described rearmament as only an inefficient and wasteful form of subsidy to industries which can find no better employment for their capital, and declared that we shall not regain self-respect by trebling the numbers of our aeroplanes. Even in February 1939, just months before the outbreak of the Second World War, the New Statesman and Nation referred to the international Bedlam rearmament race and questioned the money being made by makers of aircraft and munitions, who were described as friends of the Tory government. We now know that those aircraft and munitions provided the narrow margin by which Britain survived Hitler's aerial onslaught a year later, despite a widespread view in 1940 that Britain would not survive. History also suggests that years of arms race and merchants of death rhetoric contributed to making that margin of survival so narrow and precarious. Intellectuals played a major role in creating the atmosphere of both military weakness and political irresolution within democratic nations, which made a war against those nations look winnable to the leaders of the Axis dictatorships. In addition to thus helping bring on the most devastating war in human history, intellectuals so impeded the build-up and modernizing of military forces in democratic nations in the years leading up to that war, demonizing military equipment suppliers as merchants of death being a classic example, that this ensured that American and British armed forces would often be outgunned in battle, until belated and desperate efforts, both in war industries and on the battlefields, narrowly avoided total defeat and later turned the tide that led ultimately to victory. The wartime costs of pre-war self-indulgences and pacifist moral preening and anti-military crusades by the intelligentsia were staggering in both blood and treasure. Had Hitler and his allies won the Second World War, the enduring cost for the whole human race would have been incalculable. Neglect of history has allowed us today to forget how narrowly the Western democracies as a whole escaped the ultimate catastrophe of a victory by Hitler and his allies. More important, it has allowed us to forget what brought the Western democracies to such a perilous point in the first place, and the potential for the same notions and attitudes promoted by today's intelligentsia as by the intelligentsia between the two world wars to bring us to the same perilous tipping point again, with no assurance that either the luck or the fortitude that saved us the first time will do so again. Chapter 8. Intellectuals and War, Repeating History. The timid civilized world has found nothing with which to oppose the onslaught of a sudden revival of barefaced barbarity, other than concessions and smiles. Alexander Solzhenitsyn. Many wars have been fought in many parts of the world since the Second World War, but none thus far has been comparable in magnitude or in the range of its consequences. Like the First World War, the Second World War brought sweeping changes in the attitudes of Western intellectuals, but very different changes. As we have seen, many intellectuals who had rallied behind the Allied cause in the First World War, especially as that cause was articulated by Woodrow Wilson, turned to radical pacifism in the aftermath of that brutal and disillusioning carnage. By contrast, in the period immediately following the end of the Second World War, the tragic lessons of that war and of the years that led up to it were too indelibly etched into people's consciousness for many to return to the naive and doctrinaire pacifism that had once been so common among intellectuals in the Western democracies. The shocking differences between the behavior of democratic nations and totalitarian nations had been too recently, too graphically, and too painfully demonstrated during the war for moral equivalence to be a widely saleable commodity, even among the intelligentsia. That would come later, as the mass atrocities of Nazi Germany and Imperial Japan faded into the mists of memory, and the similar mass atrocities of the Soviet Union remained largely concealed or ignored. But in the immediate aftermath of the Second World War, evil and danger were not things that could be ignored, viewed with an air of sophisticated detachment or verbally shrouded in euphemisms. Time magazine, for example, said in May 1945 at the end of the war in Europe, "This war was a revolution against the moral basis of civilization. It was conceived by the Nazis in conscious contempt for the life, dignity, and freedom of individual man, and deliberately prosecuted by means of slavery, starvation, and the mass destruction of non-combatants' lives. It was a revolution against the human soul. The difference between the hand-wringing and navel-gazing of the 1930s and the atmosphere in the immediate post-war era was epitomized in the way the decision was made by President Harry Truman to proceed with developing the hydrogen bomb, a weapon vastly more destructive than the atomic bombs that had devastated Hiroshima and Nagasaki. This was President Truman's consultation with his advisers. Lilienthal spoke of his fears of an arms race. Acheson countered by pointing out the growing public and political pressures on Truman. Lilienthal again spoke of his own grave reservations. Truman cut him short. He did not, the president said, believe that an H-bomb would ever be used, but because of the way the Russians were behaving, he had no other course. The meeting lasted only 7 minutes. "Can the Russians do it?" Truman asked. All three men nodded yes. "In that case," Truman said, "we have no choice. We'll go ahead." The decade of the 1950s was still too close to the Second World War for the pre-war notions, attitudes, and blind spots of the intellectuals to make a strong comeback, or for the benefits of a free and decent society to be taken for granted, and its human flaws to become a reason for sweeping rejections of its norms and institutions. That would begin in the 1960s, especially among people too young to have known what the Second World War was all about, or what had led up to that catastrophe. The difference between the immediate post-war period and the later period showed up in many ways. When visiting cemeteries and war memorials in Western Europe, decades later, distinguished American military historian Victor Davis Hanson noticed a difference between the messages at American cemeteries and the messages at European war memorials. The inscriptions at American graveyards admonish the visitor to remember sacrifice, courage, and freedom. They assume somebody bad once started a war to hurt the weak, only to fail when somebody better stopped them. In contrast, the folly of war, to paraphrase Barbara Tuchman, is what one gleans at most World War II museums in Europe. The displays, tapes, and guides suggest that a sudden madness once descended equally on normal-thinking Europeans and Americans at places like Nijmegen and Remagen. Stupidity, a European visitor at Arnhem lectured me, best explains why thousands of young men killed each other for no good reason over meaningless bridges. Since the American commemorative sites were undoubtedly created first, and the European war memorials later, after European economies had recovered from wartime devastations, the differences may reflect differences in time, rather than only differences between Americans and Europeans. In the later era, people living in safety purchased with other people's lives could loftily dismiss bridges as meaningless, when in warfare the control of bridges can be a matter of life and death for armies and for the fate of whole nations. A striking example of the wide mood swings to which some intellectuals had been subject was Bertrand Russell's post-war argument that Western nations should present the Soviet Union with an ultimatum to submit to a new world government with its own armed forces, and, if the ultimatum was rejected, launch a preemptive war against the Soviet Union, while the United States had a nuclear bomb and the Soviets did not yet have one. As reported in The Observer of London on November 21, 1948, "Either we must have a war against Russia before she has the atom bomb, or we will have to lie down and let them govern us. An atomic war would be one of extraordinary horror, but it would be the war to end wars. Fearing the horror of a future war was no way to prevent it. Anything is better than submission." There could hardly be a greater contrast with Bertrand Russell's pre-war advocacy of pacifism and unilateral disarmament, or with his subsequent return to that position. A decade later, Lord Russell said, "I am for controlled nuclear disarmament." But if it proved to be impossible to get the Soviet Union to agree to that, he was for unilateral nuclear disarmament. He added, "It is a bitter choice. Unilateral disarmament is likely to mean, for a while, communist domination of this world of ours. But if the alternatives are the eventual extinction of mankind and a temporary communist conquest, I prefer the latter." After his return to his earlier pacifist and unilateral disarmament position, Bertrand Russell condemned those in the West who supported nuclear deterrence policies as people who belonged to the murderers' club. In this later period, Bertrand Russell described British Prime Minister Harold Macmillan and American President John F. Kennedy as the wickedest people that ever lived in the history of man, and as 50 times as wicked as Hitler, because Russell depicted their promotion of nuclear deterrence as organizing the massacre of the whole of mankind. Whether as an advocate of preventive war or as a radical pacifist before and afterwards, Bertrand Russell sought sweeping and dramatic solutions. While his particular solutions were unusual in both cases, what was far more common among intellectuals was to think of the world in terms of dramatic solutions of some sort, and to have their complete reversals of positions as to what specifically those solutions might be, as among intellectuals in general during and then after the First World War, leave them nevertheless confident that their superior wisdom and virtue should guide the masses and influence national policies. Clearly, at least one of their mutually incompatible positions had to be wrong, suggesting the old but apt phrase, often wrong, but never in doubt. Replaying the 1930s. The 1960s and the Vietnam War brought a more general return to the intellectual and ideological climate that had reigned during the 1920s and 1930s. Indeed, many of the very words and phrases of that earlier time reappeared in the 1960s, often put forth as if they were fresh new insights, instead of old notions already discredited by the course of history. For example, disarmament advocates once again called themselves the peace movement, and called military deterrence an arms race. Once again, the argument was made that war solves nothing. Those who manufactured military equipment, who had been called merchants of death in the 1930s, were now called the military-industrial complex, and were once again regarded as a threat to peace, rather than suppliers of the means of deterring aggressor nations. The Oxford Pledge by young Englishmen of the 1930s to refuse to fight for their country in war was echoed during the 1960s by young Americans of military draft age who said, "Hell no, I won't go." Graphic depictions of the horrors of war were once again seen as ways to promote peace, and a one-day-at-a-time rationalism was again considered to be the way to deal with issues that had the potential to escalate into war. Replacing the rhetoric of moral outrage with a more non-judgmental pragmatism and trying to see the other side's point of view were also part of this resurrected vision from the era between the two world wars. Few who espoused these and other ideas from the 1930s recognized their antecedents, much less the disasters to which those antecedents had led. Most of the notions among the pacifist intelligentsia of the 1960s and later had appeared in British Prime Minister Neville Chamberlain's speeches back in the 1930s that were published as a collection in his book In Search of Peace, which appeared just months before the outbreak of the Second World War that these notions helped bring on. More important, as too often happens, words became preemptive, disarmament being axiomatically equated with peace, for example. To disarmament advocates of his day, Churchill had said, "When you have peace, you will have disarmament," not the other way around. But there was seldom even an attempt to test this hypothesis against that of those who automatically transformed disarmament advocates into the peace movement. The Vietnam War. Among the many implications of the war in Vietnam was that it once again illuminated the role of the intelligentsia in influencing the policies of a society and the course of history. That role was not the role that Machiavelli once sought, the role of directly influencing the thinking, beliefs, or goals of those who wield power. In modern democratic nations, the intelligentsia can have influence, sometimes decisive influence, by creating a general climate of opinion in which it becomes politically impossible for the wielders of power to do what they believe needs to be done. As already noted in Chapter 7, Stanley Baldwin, by his own later admission, dared not tell the British public that Germany was rearming in 1933 for fear of losing that year's election, because saying that Germany was rearming implied that Britain needed to rearm, and the dominant climate of opinion at the time would have rejected that conclusion, and whoever was the messenger bringing that bad news. Baldwin dared not tell what he knew, not simply to save his own political position, but because he knew that any attempt on his part to sound the alarm about impending dangers from Germany could bring to power the opposition Labour Party, which was totally opposed to military preparedness and would make the nation even more vulnerable than it was. In short, the climate of opinion of the times made it politically difficult for Britain to rearm adequately, as either a deterrent to war or as a means of defending itself in the event of war, even though its highest officials were fully aware of the dangers of what was at that time clandestine German rearmament, at least in the sense that the general public was not aware of it. Thus the influence of the intelligentsia was decisive, even though they failed completely to convince the country's highest officials that what they said was correct. Although the Vietnam War involved very different issues and different facts, its outcome reflected the same influence of the intelligentsia on public opinion. Whatever the merits or demerits of the decision of the United States to become a major participant in the war to prevent South Vietnam from being conquered by North Vietnam's communist government, the stark fact is that more than 50,000 Americans died winning military victories in Vietnam that ended in political defeat because the climate of opinion created by the intelligentsia in the United States made it politically impossible not only to continue the involvement of American troops in the fighting there, but impossible even to continue to supply the resources needed by the South Vietnam government to defend itself after American troops were withdrawn. With one side receiving aid from outside and the other side not, the outcome was inevitable, the conquest of South Vietnam by North Vietnam. The decisive turning point in the Vietnam War came with a massive 1968 uprising of communist guerrillas in South Vietnam during a Vietnamese holiday called Tet, an uprising which became known as the Tet Offensive, launched during what was supposed to be a holiday truce. After many optimistic statements by American political and military leaders about how well the war was going, it came as a shock to the American public that the Communists were able to launch such a massive effort in the heart of South Vietnam. Moreover, many in the media depicted what happened as a defeat for the United States, when in fact the Communist guerrilla movement was decimated in the fighting and was never the same again. Communist leaders themselves, after taking over South Vietnam, openly admitted in later years that they had lost militarily in their war with American troops in Vietnam, including during their Tet Offensive, but pointed out that they had won politically in America. During the war itself, American prisoner of war James Stockdale was told by his North Vietnamese captor, "Our country has no capability to defeat you on the battlefield," but that they expected to win this war on the streets of New York. Legendary communist military leader General Vo Nguyen Giap, who had defeated the French in the decisive Battle of Dien Bien Phu in 1954, and who later commanded North Vietnamese forces against the Americans, said candidly in later years, "We were not strong enough to drive out 500,000 American troops, but that wasn't our aim." His goal was political. "Our intention was to break the will of the American government to continue the war. Westmoreland was wrong to expect that his superior firepower would grind us down. If we had focused on the balance of forces, we would have been defeated in 2 hours. As it was, the North Vietnamese lost at least 1 million troops killed, mostly by American troops, according to one of General Giap's aides, a death toll almost 20 times that of the Americans." Looking back years later, General Giap's aide called the communist losses during the Tet Offensive devastating. A still later interview with a man who had served as a colonel on the staff of the North Vietnamese Army and who had received the surrender of South Vietnam in 1975 told a very similar story. A 1995 interview with Colonel Bui Tin produced these questions and answers. Question: Was the American anti-war movement important to Hanoi's victory? Answer: It was essential to our strategy. Support for the war from our rear was completely secure, while the American rear was vulnerable. Every day our leadership would listen to world news over the radio at 9 a.m. to follow the growth of the American anti-war movement. Visits to Hanoi by people like Jane Fonda and former Attorney General Ramsey Clark and ministers gave us confidence that we should hold on in the face of battlefield reverses. We were elated when Jane Fonda, wearing a red Vietnamese dress, said at a press conference that she was ashamed of American actions in the war and that she would struggle along with us. Question: Did the Politburo pay attention to these visits? Answer: Keenly. Question: Why? Answer: Those people represented the conscience of America. The conscience of America was part of its war-making capability, and we were turning that power in our favor. America lost because of its democracy. Through dissent and protest, it lost the ability to mobilize a will to win. As regards the pivotal Tet Offensive of 1968, the interviewer's question as to the purpose of that operation was answered plainly. Tet was designed to influence American public opinion. As for the results of the Tet Offensive, our losses were staggering and a complete surprise. Giap later told me that Tet had been a military defeat, though we had gained the planned political advantages when Johnson agreed to negotiate and did not run for re-election. Militarily, however, our forces in the South were nearly wiped out by all the fighting in 1968. This paradoxical combination of overwhelming American military victories in Vietnam and devastating political defeat in Washington was crucially dependent on the climate of opinion in the United States, a climate to which the intelligentsia made a major contribution. One of the themes of contemporary critics of the Vietnam War, both before and after the Tet Offensive, was that the war was unwinnable because it was essentially a civil war conducted by communist guerrillas within South Vietnam, though aided and abetted by the communist government of North Vietnam, rather than a war between these two nations. Well-known historian and contemporary commentator Arthur Schlesinger, Jr. opined that these guerrillas could keep fighting underground for another 20 years. The Tet Offensive seemed to be in keeping with this view, especially when those widespread attacks were depicted as a heavy blow and a setback for American and South Vietnamese military forces, and a success for the Communists in the New York Times, among other places. Nationally syndicated columnist Drew Pearson said that the United States had taken a shellacking. CBS anchorman Walter Cronkite said, "We are mired in stalemate," and while this was a less dire conclusion than some others, the size of Cronkite's audience and the fact that he had been shown in a poll to be the most trusted person in America gave great weight to his conclusion that the war was militarily unwinnable. Aides to President Johnson later said that the Cronkite broadcast had convinced the president that he was losing the public support necessary to carry on the war to a military victory. A month later, Lyndon Johnson announced that he would not seek re-election and that he was seeking negotiations with North Vietnam.